if you've been willful neglect, you must impose a penalty. There's no discretion involved. You must impose a penalty. Now, it's $10,000 per violation. If you, for example, lose a laptop that contains 2,000 patients' names, how many violations is it? 2,000. And by the way, if the violation is you didn't have a particular policy in place, for every single day you didn't have that policy in place that was required, separate violations. Those penalties can add up awfully quickly. Now, that's a mandatory fine of at least $10,000. That's if you corrected it within 30 days. If you don't correct it within 30 days because you don't like HIPAA or the horse it rode in on, it's a mandatory fine of at least $50,000 per violation. That ought to make your day, okay? Now, here's the good news. The good news is if you don't act with willful neglect, you can still be potentially subject to fines of $100 to $50,000 per violation, but guess what? If you don't act with willful neglect and you correct the situation within 30 days, it's an affirmative defense to penalties. They can't fine you. If you don't act with willful neglect and you correct the situation in 30 days. The key here is don't act with willful neglect. And if you find a HIPAA violation, darn well correct it within the 30 days, and then you can avoid the HIPAA penalties. So our goal today is to tell you what you need to do to avoid acting with willful neglect. Now, let's look at some of the HIPAA penalties that have just been imposed, the settlements that have come down just in the last year to give you kind of an idea of some of this stuff. Actually, this is in the last, like, 6 months. Hospital allowed crew to film patients and give unfettered access to the hospital, $2.2 million. So if the ABC News shows up, be careful about just giving them patient information. An orthopedic group gave x-rays of 17,000 patients to a vendor. It's one of those vendors, you give the x-rays and they extract the silver. They gave it to them, lost all these records or disclosed these records, and guess what? The orthopedic group didn't have a business associate agreement with them. They had to pay $750,000. There's 2 on this list of people where the vendors lost the information and there was no business associate agreement, and the government went after the covered entity for not having a business associate agreement in place. You need to make sure you got a business associate agreement in place. We'll talk about that later. Question?
Is that like on the x-rays even if there's no name on them?
If there's no identified, we'll talk about that in just a minute, but HIPAA only applies to individually identifiable information, okay? All right, let's see. Hospital laptop containing 13,000 patients' information was stolen from a car, $3.9 million. Business associate's laptop, $1.5 million. PT clinic posted, those are the big hospitals. Of course, they can afford to pay it. The government would never come after me because I am a very small provider. PT clinic posted patient names, photos, and testimonials on the website. Okay, $25,000. Yeah, it's only $25,000. If you're a PT, they don't make that much money, right? How many times have you got into your dentist's office and you see like all the pictures up there on the wall? Did you ever give consent? Employee left patient records behind when they moved. The investigation showed inadequate policies, 239. You can see, okay? The bottom line is those penalties can add up awfully fast, and the government is serious about this stuff.
Okay, let's
now you think, well, that's all outside. They would never come to poor little Idaho. They can't even, they don't know where Idaho is. They think it's Iowa, okay? No, there was a hospital. In fact, the first published decision involving a small entity was an Idaho hospice. This is a small Idaho hospice. They got hit up with $50,000 because of their failure to encrypt a laptop, okay? Idaho State University got hit up with how much? $400,000. Why? Because they didn't have the firewalls in there and they left their patient records exposed. All right, now that's the civil penalties. Now, civil penalties only apply to covered entities, which are healthcare providers, healthcare clearinghouses, and business associates of those entities, and health plans, okay? If you're not any of those, if you're just the office administrator, you're not liable for civil penalties, right? But guess what? You can get hit up with criminal penalties. For criminal penalties, it applies if employees or other individuals obtain or disclose protected health info from a covered entity without authorization. Penalties, $50,000 fine and 1 year in prison up to $250,000 and 10 years in prison. People have gone to jail for this for just simply snooping. There was actually a surgeon at UCLA Medical Center who was fired, so he went in there to look at, obviously his supervisors were crazy if they fired him, so he went in there and looked at all of their records. As long as I'm in there, let's see what's going on with the celebrities. And he actually went to jail for 6 months, okay? It's happened to other people too. So the bottom line is you got to take this stuff seriously. Even if you're not involved or worried about the feds, the state, under the HITECH Act, the state attorney general can come after you for sue you for HIPAA violations, $25,000 per violation. As part of the HITECH Act, they are deputizing your patients. So if your patients now turn you in for a violation and there's these settlements and fines, they get a percentage of that, kind of like a key TAM suit. Now, that's part of HITECH Act. We don't have the implementing regulations, but it's there. Okay? When that comes out, those patients are going to have an incentive now to turn you in for privacy violations. Now you're not worried about any of those guys. I'm just, you know, the feds will never catch me. Well, if you're an employee, then your employer has to take action against you. They have to sanction you. If they don't, then that's a HIPAA violation of the employer. Okay? That doesn't necessarily mean you get fired, but they have to take appropriate employment action against you. The OCR is conducting audits. They went through their initial phase 1. Now they're starting the phase 2. They send out, I know I've had some clients who've received the queries from OCR wanting your information so that you can send it back and determine whether or not you're going to be in the audit pool. So you may be audited. And I don't know, have any of you actually got in there and looked at the audit requirements? It's pretty extensive, the stuff that they've got in there. It's a little bit scary. And even if you're not worried about all of that, the grand baby up here, the big thing, you got to self-report. You got to narc on yourself. You have an affirmative obligation to report breaches of unsecured protected health information to the affected individuals, to HHS, and if the breach involves more than 500 persons in a state, you got to report it to local media. So you got to say, here I am, come and get me, okay? There is no private cause of action under HIPAA. A patient cannot sue you for a HIPAA violation per se. But what they are doing now is they're saying that, hey, HIPAA establishes the standard of care, and if you breach the standard of care, what is that? It's negligence, professional malpractice, or it could be a violation of state privacy laws. And therefore, you see cases where patients are suing for privacy violations. This one made a lot of news. It actually was not a HIPAA violation, or at least it wasn't a HIPAA case. But Walgreens got hit up for $1.44 million. Do you know what happened? There was a pharmacist, a lady worked at the pharmacist. She wanted to, her husband's ex-girlfriend came in. She was just wondering whether she had any sexually transmitted diseases. So she just hopped on there to take a look at that. Guess what? Walgreens got hit up for $1.44 million. Now Walgreens says, wait a minute, it wasn't our fault. We had policies in place. She was acting outside the course and scope of her employment. And at least in this case, the judge and the jury said, no, Walgreens, you're vicariously liable for what they do. So to those of you who just said, hey, we're relying on our policies, we don't really care, you can't just rely on the policy. You got to make sure that you're enforcing this stuff to make sure that it lasts. Now, just an aside, because this actually comes as kind of a surprise, you know, cyber liability, that's a big topic. We'll talk a little bit more about that later. The FTC is going after entities for cyber liability issues. They just hit up LabMD because of a cyber liability. Their database was hacked. Their theory is that they're going after under the Federal Trade Commission Act under two theories. Either that act prohibits unfair or deceptive acts affecting commerce. So the theory there is that when these people come out and say that, hey, we take your privacy seriously, we put in place all these privacy protections. If they really don't, then they've lied to the consumers. And then the other theory is simply, hey, in this modern age, this stuff is so sensitive that a good business ought to have this stuff in place. And if you don't, guess what? The FTC might come after you. Now, there's been about 50 of these cases, but for some reason, they're kind of flying under the radar. The bottom line is if you're a pretty significant entity, hospital, health system, or something like that, you may want to be aware of these cases too and make sure that you're complying to ensure that you don't get hit up with an FTC action against, in addition to HIPAA. But back to HIPAA, okay. All right, let's talk about HIPAA then. First of all, who does HIPAA apply to? HIPAA applies to healthcare providers, but not all healthcare providers. HIPAA only applies to healthcare providers who engage in certain electronic transactions, so things like electronic claims, transmittals, and things like that. If you are a purely paper office, you don't believe in them fangled computers. The North Koreans are after us, and they're infecting all of our computers anyway. So we're not going to have any computers. We're going off the grid. I am Ron Swanson. If you were in that situation, you're completely paper, HIPAA doesn't apply to you. Now, it's hard to be completely paper anymore. Among other things, you know, Medicare generally requires you to submit stuff electronically, so you're probably going to get sucked into that. But I do have a couple of clients who are not covered by HIPAA because they are completely paper. It also applies to health plans, including employee group health plans if you have 50 or more participants or administered by a third party. Most of you probably have a health plan at your facility or at your group. That health plan, did you know that health plan is also covered by HIPAA? That means that that health plan has to have these same protections, just like you as a covered entity has to have in your capacity as a healthcare provider, the policies and all of that stuff. Okay? A lot of people don't seem to realize that. The government really hasn't been enforcing that, but just realize out there that that health plan is covered entity and they have to be protected also. It also, in the wake of the HITECH Act, it also applies to business associates of covered entities. Okay? We'll talk about who business associates are a little bit later. Well, what does it apply to? Just like you said, it applies to protected health information, which is individually identifiable health information concerning a patient's health, healthcare, or payment for their health care. Even a patient's name, that's protected health information. You see the patient at the hospital or at the ball game, say hi, they say, your friend says, who's that? Oh, I know him from my practice. You know, they're a patient in my practice. That's a HIPAA violation. Wait a minute, I didn't disclose any protected health information. Yeah, you did, their names are protected health information. Now, it may not be a reportable breach, but that's protected health information. How about this one? True case. I can't tell you all the specifics, but I got a call a while back where an emergency physician went home at the end of the day, typed on his Facebook account under the topic stupid patient trips, stupid patient tricks about a patient who was at the ER. Can't tell you the specifics, but it involved a barbecue and gasoline, and the patient died. And I called him up and said, what the heck are you doing? And he said, can you use the patient's name? The guy's in a small town. Everybody knew who it was. So it's not only individually identifiable, but also any information that could be reasonably used to identify the individual, okay? It's not only about their health care, or it's also about their payment for their health care, the bills. That's also covered by that. It's maintained in any form of medium. It's photographs. You go into the dentist's office and see that photo up there. That's protected health information. What does it apply to? Well, obviously it applies to the unauthorized disclosure outside your facility, but it also applies to the unauthorized use or access within your facility. You shouldn't be snooping. If you don't have a reason to be looking at that stuff, you shouldn't be in there. And therefore, it could be a HIPAA violation, even if it's just another employee just in there looking around. Just talk to that physician who got sent away to prison for that. All right, that's what it applies to. Let's talk about the use and disclosure rules. If you know this slide, this is about 90% of HIPAA for most of you, okay? HIPAA says you generally have to have the patient's authorization. You can't use or disclose the information without the patient's written HIPAA-compliant authorization unless you fit within a HIPAA exception. The first exception is, as long as it's for treatment, payment, or healthcare operations, you don't need the patient's authorization. Consent's implied. The second one is for disclosures to family members and others involved in the patient's care or payment for their care, so long as the patient has an objective and the disclosure is appropriate under the circumstances, and you limit the disclosure to the person's involvement. The third exception, there's a bunch of exceptions under 45 CFR 164.512. These are kind of like the public health, public safety type stuff. These are like exceptions for, well, we'll talk about that in a minute. Okay, let's talk about that first one. So the first one and the most important one is, as long as you're using it for treatment, payment, or healthcare operations, you don't need the patient's authorization. Okay? Now, what is that? 90% of what you do is for treatment, payment, or healthcare operations, and you don't need the patient's authorization for that. Now, what if you're really into privacy, or your patient registration form says, we will not disclose your information to anybody unless you authorize us to? That's more restrictive than HIPAA. And if you agree to that, you're going to have to abide by that. Don't do that. Why would you ever want to restrict yourself to incur more liability than you would under HIPAA? Don't have that kind of information on your registration forms or the like. Or if you are going to put that, if you are going to ask for patients' name or people that you can disclose information to, at the very least have some kind of disclaimer on there that, and by the way, we're not limiting our right to disclose the information to anybody else that we're allowed to under HIPAA. Because I'll bet you, if you got that form that we won't disclose anybody, any of your information to anybody unless you tell us to, I'll bet you they're not going to authorize you to disclose it to the collection agency, okay? Or to maybe other providers, or for other purposes. Don't do that. Don't put that kind of stuff on your form, okay? So you may use or disclose the information without the patient's authorization for treatment, payment, or healthcare operations. Psychotherapy notes, that's special. Psychotherapy notes get extra protection. You generally have to have that authorization, even for treatment, payment, or healthcare operations. Okay, next one, the second exception. So if it's for treatment, payment, or healthcare operations, you don't need the patient's authorization. Unless you agree otherwise, don't agree otherwise. Second exception, okay? As long as you can make disclosures to family members and others involved in the patient's healthcare or payment for their healthcare, so long as the patient hasn't objected and you otherwise think it's reasonable under the circumstances, and you limit the scope of that disclosure. If the patient's present, you may disclose if the patient agrees to the disclosure or has a chance to object and does not. If the patient's unable to agree, you may disclose if the patient is not objecting and you determine it's in the best interest of the patient. This is the one that allows you to disclose to the wife, after you provide the surgery and you go out and talk to the wife. Now, it may be for treatment purposes, maybe if there's follow-up care or something, but if not, this would still allow you to go out and disclose to the wife or the parents, as long as the patient hasn't objected. You haven't agreed otherwise with it, okay? You have to satisfy that standard. Now, under the omnibus rule, they extended this so that it also applies to deceased persons, okay? So if the patient didn't tell you, hey, don't tell my greedy heirs after I die that this is what happened, then you can generally go ahead and disclose the information to the family even after the patient dies. All right, the third exception is that list of public safety. There's a bunch of stuff where HIPAA says you can go ahead and make these disclosures without the patient's authorization. Things like to avoid a serious and imminent threat. Let's say you're working at the hospital, patient's high on Demerol, and doggone it, they don't want to have anything more to do with the hospital. So they go out, get in their car, run over 3 people on the way to the highway, and you think, gee, I wish I could call the police on that, but HIPAA, can't disclose it. No. HIPAA allows you to make disclosure to avoid a serious and imminent threat of harm. Okay? Just make sure that you're making it to the right person. It would allow you to call the police, not, Channel 7. If there's another law that requires disclosure, HIPAA allows you to make the disclosure to the extent the other law requires the disclosure. What are some laws in Idaho that require disclosure? Abuse. Communicable diseases. What else? Workers' comp. What else? Foreigners. What else? Organ donation. She's winning the prize. Anybody else want to challenge her? Okay. Leave it to the privacy officers. Treatment of the victim of a crime. Treatment of injury from firearms. You've got to report those. Certain mental health treatment to avoid to mental health care providers. If you've got a patient that there's a serious and imminent threat, you can make. The key there is, to the extent that there's a law that requires a disclosure, then you can go ahead and make the disclosure. Now, the key there is that the law has to require the disclosure. Last year or the year before, Idaho passed a law that allows physicians to report to the Department of Transportation if a particular patient is not a good driver. The problem is that a law allows it, but it doesn't require it. And the HIPAA omnibus rule specifically says it's not enough for the law to allow it. HIPAA trumps any contrary state law, less restrictive. And so that law is no longer it's out there, but HIPAA would preempt it. Now, it may be a situation where that patient poses a serious and imminent threat of harm, so you can go ahead and call anyway, okay? But generally, they didn't consult with me or Dana before they passed that law, because we would have told them, no, you had to put the requirement in there. Okay. What are some others? Per court order, warrant, or subpoena. You get that, court order. You generally have to comply with it. Now, the rules are a little bit different for a subpoena if it's not signed by the judge. If it's not signed by the judge, you can't just ignore it unless you want to have contempt sanctions, but neither can you go ahead and disclose it. The bottom line is you have to notify the patient and tell the patient, hey, I got this information. Unless you quash the subpoena, I'm going to have to go ahead and respond. So basically, you put the responsibility on the patient, and as long as you've done that, you'll be okay. All right. So there's these other exceptions. I'm not going to go through them. If you have situations where you think there may be a disclosure, talk to your privacy officer. Hopefully pull up the regulations to make sure that the conditions are satisfied for those situations. All right, unless you can fit within one of those exceptions, treatment, payment of healthcare operations, disclosures to family members or others involved in the care, or one of those kind of public safety, public health type things, the general rule is you got to have the patient's written authorization to use or disclose their protected health information. That HIPAA authorization has to contain certain required elements. If it doesn't, then it's invalid. Go back and look at your HIPAA authorizations. I think in the documents we provided, I provided you a checklist of what has to be in your HIPAA authorization. If your HIPAA authorization doesn't contain those elements, then it's not valid under HIPAA. Probably isn't going to be willful neglect, at least based on the commentary, but still you'd want to make sure that it's been updated. These authorization forms, these consents, they tend to migrate over time. People change it, they do other stuff. So it's a good idea to go back and periodically compare it against the regulations to make sure it still complies. Let's see. Okay. In addition, HIPAA says even though you may disclose the information, we want you to take appropriate steps to make sure the person to whom you're disclosing it is really the person who should receive it. So if you don't know Jimmy's mom, and you can disclose information to Jimmy's mom because she's the personal representative, but you don't know if that's Jimmy's mom who's calling in, what do you want to do? You have to take reasonable steps to verify who she is. What do? You have her come down, do a DNA test, make sure that, no, you just have to take reasonable steps, right? Like what? What would be reasonable steps? Yeah, ask for date of birth, okay? Or a DOB, whichever you want to ask for. What else? Yeah, ask for last date of treatment. Just take some kind of reasonable steps. Police officer shows up and says they want the information. You say, what do you want, pig? No, no, I'm not. I was just kidding. No, I would never say that. I would never, ever, ever say that. What you did, you'd have to see their badge, right? You just take reasonable steps to verify that they are who they are. Yeah.
We have nothing in our records, nothing in the case of we're not going to call mom. We're not going to call her and say, listen, our letter back was, we understand that you have this relationship. We need to, one, identify who you are. We need to send them some paperwork to who you actually are, and then establish the relationship with the child. We send us that paperwork, working for the required. Never heard back from them.
Okay. And just for the people who are on the line, so you have a situation where maybe a father calls in, make sure you get information that verifies that the father is really who the father says they are. So you have to take reasonable steps to verify. In addition, HIPAA says, even though HIPAA would allow you to make the disclosure, we don't want you to disclose any more than is minimally necessary. That's the minimally necessary standard, right? That applies to almost all of your disclosures. It doesn't apply to disclosures to other healthcare providers. If that other healthcare provider says that we need all this information, you can rely on that. You don't have to second guess them. We don't want you second guessing the oncologist about what that oncologist really needs and what they don't need. So you can rely on the representation of another covered entity. As part of your minimum necessary standard, you've got to have role-based access policies. So you're supposed to have a policy in your group, your hospital, that says, okay, these are the types of employees we've got. These are their, the job descriptions of the employees. And these are the types of records that each one of those employees can take a look at. Okay? You're supposed to have those access policies. Let's talk about personal representatives. Under HIPAA, you treat the personal representative as if they were the individual. Okay? They are fungible. They are one and the same. That means to the extent that that patient could access their information, and patients have a right, that personal representative also has a right to access that information. Not only may you disclose the information to them, you must disclose it if they request it, okay, unless you can fit within another exception. So the question is, who is a personal representative under HIPAA? A personal representative under HIPAA is the person who is authorized by state law to make health care decisions for that individual. If they can make health care decisions for them, then they ought to be able to control their health information. So in Idaho, who are the personal representatives, for example, a minor? Well, remember we have that statute, Idaho Code 39-45004, which Lauren talked about, right? It's got that hierarchy. At the top, court-appointed guardian. No court-appointed guardian, it would be holder of durable power of attorney if it has been triggered. If not them, then it would be spouse, then adult child, then parent, then person with parental delegation of authority, then any other appropriate relative, and any other appropriate person, right? Start at the top, come down to the bottom. Those would be the personal representatives, okay? So a personal representative generally has the right to exercise the patient rights. Now, there are limited exceptions to that. You are not required to treat a person as the personal representative, like the parent, if, for example, you think that doing so would jeopardize the child. Maybe, for example, you think that the father is an abuser, and that by disclosing information that would jeopardize the child. In that case, you could refuse to treat them as if they were the individual. All right, so let's back up now, because I get this question an awful lot. Well, then, when can I disclose information to mom? Mom calls in, it's a minor, maybe she's here, a minor is here for, let's say, a sexually transmitted disease. Can you disclose the information to the mom? Excellent question. Why is that important?
Because if they're
14, right, so the child's 15. Well, let's say the child's 13. If that's the case, well, if the child under the statute doesn't have authority to consent for their own health care, that means mom is the personal representative, so mom, you can disclose to mom. In fact, not only may you, you must disclose to mom. You're probably going to have to disclose to mom to get effective consent anyway, right? If the kid is 16, however, apart from the fact that the statute says you can't disclose it to mom, mom would not be the personal representative because the kid can make health care decisions for themselves, assuming that they otherwise have sufficient capacity to understand the consequences of what they're doing.
But only for that diagnosis.
Only for that diagnosis. That raises a good point. What happens if you're seeing them for multiple different items? That creates a bit of a headache for you to try to parse that out. And good luck, okay? Yeah, Becky.
What about billing, though? I mean, if the guarantor, the mother, the parents are the guarantor on the account.
Oh, good question. What do you do about that? Let's say it's the minor. You have decided, rightly or wrongly, that the minor can consent to their own health care, which means that the mother is not the personal representative. Who do you bill? Because if you send the information to the mother, she's going to have information now. What do you do? Well, let's okay, so the question is, it's communicable disease, you can't bill for it, okay? So let's step back, that's true. But let's step back, let's say it's not a communicable disease, let's say they're just in there for pregnancy test, how's that? Okay, or contraceptive, let's do contraceptive, okay? So in that particular situation, you want to bill for that test, minor has the authority to consent to their own health care. You've allowed them to consent, so mom is no longer the personal representative. Can you make the disclosure? Well, is that disclosure for purposes of treatment, payment, or health care operations? Probably for purposes of payment, right? So you may be able to disclose it to mom, but you have to use the minimum necessary standard, right? You can't disclose more than is minimally necessary. The bottom line is, that's a real hassle, and it's a little gray in that, so you have to be very, very careful about those situations. That's why you have to be really careful about making the decision to treat a minor as if they have the authority to consent, because essentially by doing that, you're saying, we're not going to disclose it to the parent without your consent, okay? Or at least, you know, if you object otherwise. So be careful about picking up that consent stick, because it means you're also picking up the disclosure stick and the other end of the stick. So be careful about making that decision. All right, let's see. Let's talk about business associates. This is important because remember, yeah. Okay, the question is, what about parents who are divorced? What about it? When you can disclose information to them? Okay, yeah, I mean, you've never had this situation where mom comes in and says, don't tell the deadbeat dad. I don't want him to know anything about it, except I want him to pay for it. Okay? Can you do it in that situation? Yes, you can, because in Idaho Code 32-717A, it specifically says that the non-custodial parent has a right to access the kid's records. The custodial parent can have you delete information concerning addresses, but the general rule is, under Idaho law, it gives that non-custodial parent the right to access the information. And remember, under HIPAA, the personal representative is the person with the authority to make health care decisions. Just because they lack custody doesn't necessarily mean they're not a parent and can't make health care decisions. So even under HIPAA, they would be able to access the information. So what do you do in that situation? Tell them, I'm sorry, but Idaho Code 32-717A specifically says that she has the right to do that. If you don't like it, you'll have to go to court and get some kind of an order that prohibits me from doing it, because the law says I have to make that disclosure. Okay. Now, again, there might be a situation if you felt like making that disclosure would jeopardize the child, then you might be able to refuse in that situation. Becky?
So what if the child doesn't want? child have any say in that? They're still a minor?
If the child does not have the authority to consent to their own health care, no. They don't have the capacity to do it. See, the theory is minors can't contract. They don't know enough to contract. So to be safe, we've got to look to their personal representative. That's what the law thinks. So that means that if they can't consent to their own health care, then they also can't control what the decisions concern their health information. So they may not want you to disclose it, but you just got to tell them, you know, I'm sorry. The law requires that the parents have access. I mean, you cannot refuse to give it to the parents. HIPAA says you have to treat the personal representative as if they were the individual, unless you can fit within one of those exceptions where you think it's not in the child's best interest, or you've otherwise agreed with the parent in advance so they can keep the information confidential, or one of those situations. But yeah, be careful about making promises to minors that you can't keep. All right, let's see. All right, let's talk about business associates. Remember, a couple of those recent cases came out and they cited the covered entity because it didn't have, after the business associate screwed up with the information, they cited the covered entity because there was no business associate agreement in place. Really important that you have business associate agreements. What is a business associate? HIPAA says you can make disclosures to business associates so long as you have these business associate agreements in place. A business associate is someone you want to have your health information, somebody that you're paying or contracting to do something with your health information, okay? Either to create, access, maintain, or transmit your protected health information on your behalf. They are your business associates. It would be people like your management company, billing company, your accountant, your attorney if you're sharing protected health information with them. These are people that you want to do something with your information. Note that under the Omnibus Rule Commentary, they specifically made it clear that it includes data storage entities because they are maintaining your information. Even though you don't want them to access it, they're still maintaining it, okay? So you need a business associate agreement with them. The key here is you want them to do something with your information. Well, who are not business associates? Well, your own employees, your own workforce members are not business associates. They're just part of you. Other treatment providers are not business associates. They're not there to treat you or to do something with your information. They're providing their own service, right? They're not your business associates, unless they agree to maybe provide management services or other administrative services for you. Janitors, right? Do you want your janitors accessing the information? Hey, come in there, sweep it up, and why don't you take a look at that kid's diagnosis? I'm not quite sure what's going on there, and I appreciate your thoughts. Okay? No, you don't want your janitors looking at the information. Now, is it possible they might see your information? Yeah, so what do? You get a confidentiality agreement in there, but you don't want them looking at the stuff, okay? So you don't have a business associate agreement with them. Okay, the covered entity is liable for the acts of the business associate, but only if, okay? You don't want to be liable for the acts of your business associate, okay? You're only liable if they are your agent under the federal common law of agency, which generally means that you have a right to control them, that you control the way they do stuff. Or you know that they're screwing up with your stuff and you don't act to stop it. In those cases, you can be liable for their actions. So you want to make sure that that business associate's not your agent. Put in your business associate, make it very clear, you are not acting as my agent, so I'm not vicariously liable for what you do, okay? You may have a situation where a business associate goes out and screws up. Well, one of the first HIPAA calls I got, right after HIPAA came out, I got a call from an entity, and they said, oh, we just found out that our document destruction company was taking the records down and just dumping them out of the dump. You know, and the seagulls were flying down and picking out the protected. They said, what do we do? Oh, no, the sky is falling. I said, well, do you have a business associate agreement? Yeah. Did you know that they were doing this? No. Were they supposed to do this? No. Well, you're not liable for what they did. That was the business associate's fault, as long as you didn't know and they weren't your agent. But you need to make sure you got that business associate agreement, and make sure as part of that that you're not exercising such control over what that business associate does that they become your agent. All right, let's talk about the HIPAA security rule. The other stuff you guys know about, yeah, okay, heard it all before, no big deal, we've been dealing with it. The big ticket item now for HIPAA violations is the security rule, okay? Boy, I saw this, I had to speak at some national meetings on HIPAA, and I saw this news story. Healthcare-related hacking up 11,000% since last year. I can't believe that's right, but I double-checked it, and that's what the story says. I didn't actually go out there and check with the hackers, but that is really, really frightening. I don't know much about this stuff, but apparently healthcare records on the black market get a premium, even more so than like Social Security numbers and the other stuff. And so it is a huge issue. You guys have heard about this, about the ransomware that are hitting the hospitals and the like, goes in there and locks it up. The bottom line here is security rule, this was what it was designed to protect against, was to make sure that your information not only remains confidential, but it remains still viable, that it's still accurate, and that it's available. So it's not locked up by the ransomware, that you still have it available. Okay? That's what the security rule is there for. A lot of people get frustrated, oh, security rule, blah, 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 blah. Hey, as a business, you ought to be doing this stuff, separate apart from the regulations. You'd have to have this stuff in place. So what does the security rule require? You have to conduct a risk analysis. A lot of you probably have not done it or haven't done it since 2005. That's not a good deal, okay? Then you've got to implement certain administrative, technical, and physical safeguards, and you've got to execute your business associate agreement. That's kind of the guts of what the security rule is. As far as that risk analysis goes, they want you to go in there and analyze where your information is coming from, what happens to it, where it goes, and what are the risks associated with it. Now, some people will pay thousands of dollars to go out there and have a consultant to come in there to do it. You're not required to do that under the rule, okay? Specifically, on March 28th of 2000, I think it was 2014. I remember it's March 28th because it's my birthday, and I was very appreciative of them doing this on my birthday. I feel like this is the government's birthday to me, okay? It's a birthday present, okay? They came up with a security risk assessment that you can go in and access for free at the healthit.gov website, and it's got a process, a tool that you can use to do your own security risk assessment if you don't want to pay thousands of dollars to have some outside vendor to come in there and do this. Now, it's only as good as the data you put in. So you may do your risk assessment. It may or may not provide you the protection you need from hackers, but it would probably protect you if the government comes in and does an audit. You could at least say you did the security risk assessment as long as you did a good faith basis. If you really want to make sure that you're protected, though, you may want to look at an outside vendor or make sure that your IT people know what they're doing. But this is a good option for those of you who haven't done a risk assessment, you don't want to spend thousands of dollars, and you've otherwise got a qualified IT person that can help you do this. Use this, because the government can't really fine you for using their tool, right? Yeah.
Tim, are you seeing a lot of your clients moving towards cyber insurance coverage?
The question is, am I seeing a lot of my clients move towards cyber security insurance? I'm not sure that question comes up very much, so I don't always see, but my recommendation, we'll talk about a little bit later, is yeah, I think you'd ought to consider that. Now, the good news is even if you don't purchase cybersecurity insurance, some of your other policies may provide some coverage. In fact, there's a high-profile case going on right now where the court just found that just under a general liability policy, it provided coverage for a hacking attack. So your existing coverage may already apply. Of course, the insurers will probably go back and rewrite the policies now to address that, but I think it's a good idea because, for example, not even for HIPAA reasons, as long as you don't act with willful neglect, I'm not really worried about HIPAA fines or penalties. I've never had a client get hit with fines or penalties yet. I've always been able to get them off, okay, because we were able to show that they didn't act with willful neglect. I'm not so much worried about the HIPAA fines and penalties. I am concerned about the costs of lawsuits and things like that for individuals who might start suing you. And I think that having cyber liability insurance for that type of stuff, I think it's a good idea. But you need to check with your broker, make sure that you've really got a good product that's going to protect you for the types of things you want to, because there's a lot of products that are out there, and the exceptions are so large that you really haven't got any coverage at the back end of it. So, good question. All right. The government has also given you additional guidance on their website. The government's OCR website, OCR/HIPAA, has a wealth of information, including a lot of stuff on how to conduct a security risk analysis, what you need to have in it, and the like. Okay, once you've done that risk analysis, you've got to implement your administrative, technical, and physical safeguards. Each of those has specific standards. Those standards are either required, they have specifications. Some are required, which means they're required. Okay? Imagine that. You got to do that. Some of them are addressable. If they're addressable, that means that if you've got a reasonable basis for not doing it and you can come up with some other method that provides the same level of protection, you don't have to do the addressable one, but you better document that you've done the analysis and come up with a reasonable alternative. Okay? These are the standards for the administrative safeguards, things like policies and procedures for workforce security, blah, 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 all that stuff. For physical safeguards, things like facility access controls, workstation use, and so forth. And technical safeguards, access controls, audit controls, and so forth. In the materials I provided to you, I've given you kind of a checklist of the security rule standards and the requirements in there, so you can go in there and you can look and make sure that you've got that. Separate and apart from HIPAA, you guys need to do this. So you're not the next person that's hit up with ransomware. You know, you may think it's just the big hospitals. I had a small physician practice in a remote part of Idaho call me the other day because they were hit up by ransomware. Okay. All right. Lots of information on the government's healthit.gov that we'll talk about, give you information and guidance for complying with the security rule. You can spend your time taking a look at that. Let's talk briefly about encryption. Okay. This is a kind of a hot topic right now. Encryption is an addressable standard. That means that you don't have to encrypt your data, but only if you determine it's not reasonable under the circumstances and you come up with another method that provides you adequate level of protection. Hard to do that, okay? Hard to find another method that's not going to provide you with the same level of protection as encryption. So encryption is really important. Why? Because if your data is encrypted, then it is deemed to be, and it's encrypted according to the standards, it's deemed to be secured. What does that mean? That means you don't have to report breaches of it or the loss of the laptop because it's secured, okay? On the other hand, if you lose data, electronic data, that is not secured, that is not encrypted, that is presumed to be a reportable breach. So, doggone it, I can't find that USB, or that laptop was stolen. You saw examples of the penalties that came down. Okay? And those were because it wasn't encrypted. Okay, the OCR is giving us guidance concerning what you need to do in order to make sure that it's properly encrypted under the standards. Let's talk about communications by email or text, okay? Well, let's see, do you ever have providers who are emailing or texting information, protected health information about your patients? Probably. If that is, well, is that data encrypted? Not if they're using the open network or not in the general texting. That's not going to be encrypted unless you've got a specific application for it. Well, does that mean it's a security rule violation? Well, encryption is an addressable standard. So unless you come up with an alternative that provides the same level of protection, yeah, you're violating HIPAA by sending that stuff via text or via internet. Are you communicating with your patients over the open internet? If you are, and it's not encrypted, then you're violating HIPAA unless with an alternative addressable standard. Now, the omnibus rule did come out and say that when it comes to communications with patients, okay, patients have a right to communicate with alternative means or alternative locations. That means patients have a right to come to you and say, hey, I want you to communicate with me via email. So they have a right to request that. And HIPAA says, the OCR says, yeah, okay, you can do that as long as you alert the patient that that information may not be secure, but if they still want to do that, that's fine. So if you want to email or text your patients, you should be asking them, letting them know, hey, this isn't secure, but as long as they say, fine, go ahead and do it anyway, then you can go ahead and email them and text them. We got that specific guidance. Does that apply to other providers? No, probably not. So encryption is the standard. I suppose you could probably get the patient's authorization to send it via unencrypted data, but that's probably going to hard. I'm not sure how many of you are going to go out and get the patient's authorization for that. Would you mind if our providers communicate about you without, you know, putting in proper place encryption and stuff like that? I don't know. That's probably a hard sell. In implementing your security stuff, again, the healthit.gov has a bunch of information for you that can give you guidance concerning implementing this stuff. Mobile devices. That is another hot topic and a real concern, whether it's posting patient photos, sending stuff via text or email, or just downloading information. Your providers, probably if you pulled up their mobile device, they probably got a lot of protected health information on there. And I bet you it's not encrypted. And that means if it's lost or stolen, guess what? You probably got a reportable breach. And remember, each one of the names that are on there, separate violation. So make sure that you carefully consider your mobile devices when you're doing that security risk analysis and when you're developing your security plans. It's so important that the government has a specific website that talks about, and a training program that talks about mobile devices. As part of the security rule, you've got to document your written policies and procedures. You got to maintain the documentation in an electronic format, and you got to maintain the documentation for 6 years. Okay. Any questions about the security rule? I realize I went through that very fast, but I was born in 1962, and so I don't understand the technical stuff. So. Okay. Let's talk about HIPAA and patient rights. HIPAA gives patients certain rights concerning their information. Specifically, those rights that are up there. Let's talk about each one of those. The first is patients have a right to receiving notice of their privacy practices. That's that document you all know, you love, you give it out, the patient never reads it, they just throw it back and drop it on the floor, and you just put it in, add it to the stack, somebody else looks at it the next day. Okay? That notice is kind of like your contract with the patient about how you're going to treat their information, right? That notice has to contain certain requirements, certain elements. In the documents we provided to you, I've given you a checklist for your notice of privacy practices. Like your authorizations, if you haven't updated that since 2013, you're out of date and you need to update it. Even if you have, it's a good idea to go back and periodically look at that, because quite often I find in the notice of privacy practices, you commit to things that HIPAA doesn't require and that will get you in trouble. Or you have things that are in there that are simply wrong. So it behooves you to periodically go back and look at the notice of privacy practices and compare it to what you really need to have in there. Take a look at that. Direct treatment providers have to give that notice of privacy practices to the patients no later than the first date of treatment. If you're providing treatment via telehealth, you're supposed to have some process in which you can communicate that notice of privacy practices to them. You've got to make a good faith effort to obtain the patient's acknowledgement that they received a notice of privacy practices. So they initial something that says, I received this on this or a prior occasion, part of your registration process. Let's see. If you maintain a website, you've got to post a copy of your notice of privacy practices on the website. You've got to also post it in your facility. Okay? That's the notice of privacy practices. You've got to, in addition, the patient has a right to request restrictions on your use or disclosure of protected health information for treatment, payment, or healthcare operations. Stop and think about that for a minute. Okay? Now, wait a minute. Stanger just told me that I don't need the patient's authorization to use or disclose information for treatment, payment, or healthcare operations. He also told me not to agree to it. And yet this says a patient has a right to request those restrictions. Yeah, the patient has a right to request it, but you don't have to agree to it. My kids ask me stuff all the time, and I don't have to agree to it. Okay? Same thing. You don't have to agree to it, and don't agree to it. You're entitled to use it for treatment, payment, or healthcare operations without the patient's authorization. Don't agree to do otherwise. Okay? If you do agree to do otherwise, you're bound by it. So don't agree. There's one limited exception. Under the omnibus rule, they came out and said, if the patient comes in and pays for their health insurance, I think this is the question that you asked. Patient comes in there and pays for their whole episode of care for their health insurance and says, don't disclose it to my health insurer. In that situation, you must comply with that request. That means somehow you segregate that data so that the health insurer doesn't have access to that data and you don't disclose it. Okay? That's probably, as a practical matter, pretty hard to do. The good news is that only applies if the patient asks for it. So I certainly wouldn't be asking the patient when they come in, hey, by the way, do you want me to disclose this to your health insurer? No. Okay? It only applies if they ask, so don't ask, don't tell, then you don't have to worry about it. If they do, though, you're going to have to come up with some way so that you segregate that information so it's not provided to the health insurer. Next right, a patient has a right to request communications by alternative means or alternative locations. That's the one. The patient comes in and says, hey, I want you to text me or email me, or I want you to send my information to me at work, not at home, because I've got an abusive husband, and he knows that I'm here seeing an OB, and he's going to beat me up when I get home. Okay, as long as they ask for it, it's a reasonable request, you have to comply with that reasonable request to receive information at alternative means or at alternative locations. Okay. Next, a patient has a right to access their protected health information, but not all their information, only the information that's maintained in the designated record set. The designated record set are basically those records that constitute the health record that you use to make decisions concerning the patient's health, healthcare, or payment. It's not things like QA, it's not credentialing, it's not that other stuff. It's the stuff that you use to make healthcare decisions. Note that it doesn't matter who created it. If you get records from another healthcare provider and it's in that designated record set because it's relevant to your treatment, you use it for the treatment, the patient has the right to access that also. I get this question all the time. Well, but we don't have to produce the records from Dr. Jones, right? Yeah, you do. If it's in the designated record set, it doesn't matter who created it, you have to produce it. There's certain rights that go along. You've got to respond to requests for access within 30 days. You must provide the records in the requested form if readily producible. You may require that the request for that information be in writing if you want, which I always do because I want them to specify exactly what the record. Because you get the request, what do they say? I want a copy of all my records. Do they really want all their records? No. So you explain it to them and then you have them document what they're really after. You may charge a reasonable cost-based fee for those records, okay? It says you may, it's not that you must, but it has to be a reasonable cost-based fee. That means you can't charge them a surcharge because they're ugly and you just don't like them, or that they're problems and you don't want it, or that because there's malpractice stuff hidden in there, we're going to charge them $100 a page so they won't ever get it. No, you can only charge them a reasonable cost-based fee, which is the cost of the actual labor and materials in making the copies, not some kind of additional administrative time or some kind of normal fee. It has to be a reasonable cost-based fee. These are for requests from the patient. Now, if the attorney or somebody else asks for it, you can generally charge them whatever you can get away with. Except workers' comp. You have to provide the first set of workers' comp records free of charge. If you get that request for access to protected health information, you got to check with your privacy officer to make sure that you're complying with those requests. Oh, by the way, the government just came out with new guidance concerning access to protected health. If you haven't looked at that, I think it behooves you to take a quick look at that because there's a lot of information in there about access. And the government's really into allowing people to access their information. So, in fact, one of the largest fines under HIPAA so far was $4.3 million. Was it a privacy violation? No. It was that they refused to timely respond to 45 requests for patient information. Actually, it's only, I think, $1.3 million for failing to do that. The other $3 million was they blew off the OCR when the OCR came to find out what was going on. So grant access, do not blow off the OCR. All right. Patient also has a right to request amendment of their health information. What? That means that the patient doesn't like my diagnosis, they can come in there and have me change it? No, not necessarily. Note that they have a right to request the amendment. You don't have to grant the amendment if, for example, the information was right. You don't have to change it. Or if the information was created by somebody else and the other person's no longer available, okay? But you do have to acknowledge and respond to their request, including giving them a denial on the basis for it. If you do make the amendment, it has to become part of the amendment. It doesn't mean that you go in there with white out. You just do an appropriate records amendment, okay? And or attach the amendment to the record. And then that goes wherever the amendment goes, okay? If you deny the request, you have to let the patient know why you denied it. And the patient has a right to then have a statement of their disagreement attached to the record, and that becomes part of the record, and then it has to go with it wherever the record goes. There's some additional stuff that goes along with requests for amendment. If you get a request for amendment, turn it over to the privacy officer. If you happen to be the privacy officer, along with the office manager, the risk manager, the cook, the bottle washer, everything else, then open up and look at the regulations, okay? 45 CFR 164.526. Finally, patients have a right to receive an accounting of disclosures of information that you've made. An accounting of disclosures of their information that you've made. Now think about that. Are you tracking that? Every time you send it to Dr. Smith, Dr. Jones, you track that? That's not, at least under the current rule, what you have to do. The only thing you have to account for are just essentially those disclosures that are made to public agencies under .512 or improper disclosures. You have to do an accounting, keep a log of that. That log has to have the date of the disclosure, the name of the entity receiving the disclosure, description of the information disclosed, and describe the purpose of the disclosure, okay? That's what you have to have on your accounting log. How many of you have ever had a patient come in and ask for an accounting of disclosures? 1, 2, 3 out of 4. 4 out of, what, 130, I think is what we had registered here. Yeah, it doesn't happen very often, so we don't need to worry about it, right? Well, if they do, and you don't have it available, guess what? That could probably be willful neglect. You can get hit up with those fines and penalties, so you're supposed to track that. Also, under the omnibus rule, under the High-Tech Act rule, under the High-Tech Act, they will, if you maintain electronic health records, then you will also have to provide some kind of report that discloses additional disclosures for treatment payment or healthcare operations, but we don't have the final rule on that yet, okay? So we're waiting, at least my advice to the client is let's wait until we get the final rule and then we'll see what we have to account for in our electronic health records. If you're in the process of purchasing the electronic health records, make sure you keep that in mind, that you're going to have the functionality that you need in order to provide those required reports, whatever the heck they're going to be whenever they issue the final rule. Okay. Yeah, Becky.
Would you clarify for me what has to keep on that log?
So the question is, what do you have to keep on the log? The types of disclosures you have to make to keep on your log are improper disclosures, so disclosures in violation of the privacy rule. Also, essentially disclosures that are made under 45 CFR 164.512, that's the disclosures to avoid imminent harm, disclosures per a subpoena, those types of things, okay? Those are the types of things you would need to disclose. And you only have to provide that if the patient shows up and requests it. Okay, let's talk about some of the administrative requirements then. HIPAA requires you all to have a designated privacy officer and security officer. They can be the same person if you want. They can be different people, but you're supposed to designate them in writing so the government knows who to slap around when they show up to do the investigation. You need to train your workforce concerning all these rules, and you want to document your training. Why is that important? Because if you have a rogue employee that goes off the deep end and discloses this information, if you can show you provided that training, guess what? There may still be a violation, but you probably didn't act with willful neglect, and you can avoid fines and penalties. On the other hand, if you provided no training, that may be willful neglect. You've got to implement the written policies and procedures, respond to complaints and violations, mitigate improper disclosures when there is one, maintain the HIPAA documentation for 6 years. That's not all medical records. That's just the documentation that's required by HIPAA, like your notice of privacy practices, your authorizations, that type of stuff. And you've got to implement reasonable safeguards. Reasonable administrative, technical, and physical safeguards. What are reasonable administrative, technical, and physical safeguards under the privacy rule? Under the security rule, we know what they are because they specifically tell you what you're supposed to do. Privacy rule, not so specific. What are the reasonable safeguards? They're the ones that the OCR tells you you should have had in place after they show up to investigate you, right? No, it's the kind of reasonable. So like locking doors, not leaving stuff out lying around, you know, maybe having password protection, you know, things like that. You don't have to go nuts with it. You just have to put in place reasonable safeguards. Now, those reasonable safeguards are important for another reason, and that's because as long as you have in place reasonable safeguards and you have an incidental disclosure, that's not a violation of the privacy rule, which means you don't report it. What is an incidental disclosure? That's a disclosure that just kind of happens in the course of things, but you otherwise had reasonable safeguards in place. You know, things, look at, privacy is not perfect. It's not like the Get Smart, you know, cone of silence that it drops down and when you have a conversation in the hallway, nobody can overhear. You know, you go in, for those facilities, you know, you have the curtain between the two beds and you pull across that. That's completely soundproof, right? Nobody hears through that thing. Okay, incidental disclosures, you know, they happen all the time. But as long as you have reasonable safeguards in place, that's not a HIPAA violation. So you need to have the reasonable safeguards in place. Okay. All right, that brings us to the breach notification rule. Looks like I'll be standing up here. So under HIPAA, in the wake of the omnibus rule, actually in the wake of the High-Tech Act, they now require you to narc on yourself. You have an affirmative obligation to report a breach of unsecured protected health information. If there's a breach of unsecured protected health information, you've got to notify the affected individuals. You've also got to notify HHS. So anytime you're going to have to notify the individuals, you're also going to have to notify the HHS. The only difference is the timing. And if the breach involves more than 500 persons in a particular state, you've got to notify local media. If you're a business associate and you experience a breach, that business associate also has to notify the covered entity so the covered entity can do the breach reporting. The key there is it has to be a breach of unsecured protected health information. That's the key to this. So what is unsecured protected health information? Unsecured protected health information is information which is not secured. So how do you secure the information? Two ways. The first is you completely destroy it. I always thought that was interesting. If you completely destroy it, how in the world could there be a breach anyway? But that's one way. You completely destroy it. The other way for electronic data is it is encrypted based on the standards that are adopted by the government. If it is encrypted, even though you lose the laptop or the PDA, even if you lost it, if it's encrypted, it's not a breach because it's secured health information. It's not unsecured, so you don't need to report it. So you want to make sure that you have that stuff encrypted, okay? Now, most of the stuff that you've got is not going to be secured. So therefore, what we're usually dealing with a breach situation is whether or not a breach has occurred. So what is a breach? The acquisition, access, use, or disclosure of PHI in violation of the privacy rules is presumed to be a breach unless the covered entity or business associate demonstrates that there is a low probability that the information has been compromised. That's the standard. The acquisition, access, use, or disclosure of PHI in violation of the privacy rule, not the security rule, but in violation of the privacy rule, that's presumed to be a breach unless you can demonstrate that there's a low probability that the data has been compromised. How in the world do you demonstrate that? By 4 factors. The first factor is the nature and the extent of the protected health information involved. The second, including, for example, was this just simply the name that the patient was a patient at the hospital, but no other information, no account information, no social security, no diagnosis, you don't know why they're a patient, just simply the name that they were a patient at the hospital, probably a low probability that the data has been compromised. On the other hand, if you're disclosing diagnosis, social security number, account information, that type of stuff, higher probability you're probably going to have to do the breach report. The second, who got the information? Was the information going to another healthcare provider who knows and has to keep the information confidential? If so, probably a lower probability. On the other hand, if it's going to the local mafia boss, probably a higher probability you're going to have to report. Third, whether the information was actually acquired or viewed. That's interesting. Even if you don't know that it was actually acquired or viewed, you still may have an obligation to report. Okay. The fourth is the extent to which the risk has been mitigated. So if you were able to take immediate steps and mitigate any risk, then you may not have an obligation. So you do these 4 factors to assess whether or not there's a low probability that the data has been compromised. Okay. Now, HIPAA contains certain exceptions. In certain exceptions, you're deemed not to have had a breach occur. These are quite frankly not very helpful. These are kind of the disclosures internally where the doctor talks to the wrong nurse or the nurse looks at the wrong record, but there's no future disclosures within the facility. Those are not deemed to be a breach. The third one is a little bit more interesting. That says that there is no breach if the disclosure of PHI where the covered entity or the business associate have a good faith belief that the unauthorized person receiving the information would not reasonably be able to retain the information. So apparently if the person receives it has a short-term memory problem, you may be okay. We don't know exactly what that means. Other than the examples that they gave was you go out and the nurse gives discharge instructions to the patient only to realize, oh my gosh, that's not the right patient. She immediately grabs it back before the person can read it. Or you send out EOBs, but you send out the EOBs with the wrong patient's information, but the EOBs come back and it was never opened. In that situation, you can conclude that there was no breach that occurred in that. So to determine if a breach is reportable, these are the questions you got to ask. Was there the unauthorized access, use, or disclosure of unsecured protected health information? Okay, has to be PHI. Was it unauthorized? Second, did it violate the privacy rule? Remember, incidental disclosures are not violations of the privacy rule, so you don't have to report those as long as you have reasonable safeguards in place. 3, does one of those exceptions apply? The internal disclosures or where the person couldn't retain it. 4, assuming that all of those are yes, then it comes down to this. Is there a low probability that the data has been compromised based on those risk assessment factors where you go in there and document that risk assessment? That risk assessment, the bottom line is if it's close at all, I would report. Because probably the violation itself, the breach, probably wasn't willful neglect. Assuming you have your policies in place and the other stuff, that's probably not willful neglect. On the other hand, if you consciously make the decision not to report when you should have, the government has said, hey, that probably is willful neglect. You couldn't get fined for the original one, but if you failed to make the report, you might be fined. That's a mandatory fine of at least $10,000 per violation. That's if you corrected it within the 30-day period. So let's assume that you've gone through that analysis. You've concluded that, yes, there is a reportable breach. What do you got to do? Well, you've got to notify the covered entity. You got to notify each individual whose unsecured information has been or is reasonably believed to have been accessed, acquired, used, or disclosed. So you got to tell a patient. You got to tell HHS. And you got to tell local media if the breach involves more than 500 persons in the state. The notice to the individual, you've got to provide that in writing. Even if the patient is the one who brought this to your attention, the government still expects you to send them a letter. And you got to provide that by first-class mail. My theory is this is the government's way of making sure that the post office stays in financial good terms, okay? So you got to provide that by first-class mail. That 60 days runs from the date that anybody in your organization knew about the breach other than the person who committed it, okay? It doesn't run from the time that the privacy officer got notice of it. That 60 days runs from the time anybody in the organization knew about it, okay? You want to train your people so that they report immediately. Why? Because you've got that 60-day clock ticking. More importantly, you want to jump on this and respond immediately so that you can mitigate any risk. Because if you can mitigate the risk, that is a factor in determining whether or not you even need to do a breach report. And if nothing else, you want to be able to correct it within 30 days. Why? You correct it in 30 days, what happens? As long as you didn't act with willful neglect, you can avoid fines or penalties. You want them to report these to you as soon as possible. And you want to train your people and have your policies that require them to do those reports as soon as possible. That notice that you send out to the individuals, it's got to contain a brief description of what happened, including the dates of breach and discovery, a description of the types of unsecured information that was involved, was it diagnosis, progress notes, social security numbers, whatever. The steps they should take to protect themselves, whether that might be, getting the credit monitoring or contacting so-and-so or sending out their enforcer, I don't know what it is. A brief description of what the covered entity is doing to investigate, mitigate, and protect against future breaches. What are you doing to correct the situation? Contact procedures to ask the question so that they can contact you to get more information about what happened with the breach. You got to send that written notice by first-class mail to the last known address. You can send it by email, but only if the patient agrees to receive it by email. If the person's dead, you send it to their next of kin. In urgent situations, you may also contact the patient by phone or other means, but you still got to send the written notice in addition to that. Well, what happens if you lack sufficient contact information to be able to contact the patient because it concerns information that was from, years ago? If you lack sufficient contact information, you've got to provide substitute notice from that's reasonably calculated to reach the individual. If it's less than 10 persons, you can do it by, written notice, telephone, or other means. If it's more than 10 persons, then you've got to conspicuous post on the covered entity's website, or include a toll-free number so that they can contact you for 90 days, okay? That's the notice to the individual. If you think you've got a breach that's reportable, go through that analysis, talk to the privacy officer, make sure that you're complying with the requirements to give that notice. Anytime you have to notify the individual, you also have to notify HHS, okay? The only difference is the timing. With the timing with the HHS, if the breach involves fewer than 500 persons, you can wait until 60 days after the end of the calendar year. So if we had a breach today, then you could wait until, let's see, it's not a leap year next year, so it would be February or March 1st of next year to go ahead and make the report. My theory is that if it's not a significant breach, wait till next year when they do that, because everybody else is going to be making their report at the same time. OCR is going to get millions of these things, and yours will get lost in the mix. That's my theory. I'm not sure whether that really works. If it is a significant breach, then you may want to go ahead and report it now, just so that you stay ahead of the curve and you beat the patient to the punch if they're going to turn you in. Now, if the breach involves more than 500 or more persons, then you've got to report immediately. You've got to report at the same time you report to the individual. You submit that report by going to the government's website here. There's an electronic submission that you go ahead and you fill out, and the information is relatively detailed about the information that you provide, so it may be difficult to wait till next year and still retain all that information so that you can disclose it. If the breach involved more than 500 persons, your name goes on the HHS wall of shame, along with all those other people who had breaches of more than 500 persons. In addition, if the breach involves more than 500 persons in a state, then you've also got to contact local media. When you contact local media, for heaven's sakes, don't provide more protected health information through local media. Note that that is 500 persons within the state. So if you had like 400 people in Idaho and 300 people in Oregon, you would not have to notify local media. It would only be if you have more than 500 persons in a particular state. Notice by the business associate. If you're a business associate, you have an affirmative obligation to narc on yourself. If you have a breach, you've got to notify the covered entity so the covered entity can go ahead and do the report. In your business associate agreements, hopefully you've got contracts. You've got your business associate agreements. You're going to want to address breach reporting in that. Hopefully you would require your business associates to report sooner than the 60-day requirement because you want to respond on these as soon as possible, right? All right. That gives us to our HIPAA Top 10 list. Any questions on that stuff? Yes, ma'am.
So somebody faxes or gets pushed in wrong, the plumber writes back on it, you know, that is wrong.
Okay, I'm going to stop you right there just for the people who are offline. So let's say you have a physician practice and they send information to the wrong fax number. That never happens. Yeah, okay. So?
The one side of that, the other side is when we send records out to patients that their primary care is, but you get the note back saying this provider not with us, not our patient.
Okay. So the other question is you send it to a provider and only to find out that that provider's moved on and they're no longer there. Okay. All right, so let's talk about the first one. Let's go through the analysis. You send out the fax and you send it to the wrong entity. Is that a breach? Was the information secured? No. It wasn't encrypted, so it's not secured. Was there the unauthorized acquisition, access, use, or disclosure of protected health information in violation of the privacy rule? And if so, is there a low probability that the data has been compromised? Well, there was a violation of the privacy rule because you sent it to the wrong location, right? So then the question is whether or not there's a low probability that the data has been compromised. So you'd look at those 4 factors. Who got it? The plumber? Yeah, he's not obligated to keep it confidential. What type of information was in it? Was it just the fact that the person's a patient with no other identifiable information? Well, you might be okay there. If it's the diagnosis code, progress notes, that type of stuff, yeah, it's probably going to be reportable, okay? Did the guy look at it? Probably so, because he called you, right? Okay, in that situation, I would probably conclude that it is reportable, and I would do the reportable breach. I would do the breach report in that situation. Okay, let's talk about the other situation where you sent it to the wrong physician's office. Okay, was there a breach? I'm not sure even that there was a breach because the disclosure was for purposes of treatment. So even if there was a breach, there's a low probability that the data has been compromised because it went to another healthcare provider who is obligated to keep it confidential anyway. Under the commentary that came out with the omnibus rule, they suggest that that's a factor that would suggest that there's a low probability that data has been compromised. As long as you jumped on it and said, hey, thanks very much, appreciate you letting us know. Please confirm that you destroyed all this information, that none of it's out there anymore, and that you have not and will not disclose it to anybody else. In that situation, I think you've got a pretty good case that based on the commentary that we've gotten that there's a low probability that the data has been compromised. Okay. Good question. Any other questions? Did I scare you guys? Yes, ma'am.
What about appointment cards when you checked out appointment cards?
Okay, appointment cards. The appointment cards are switched. Again, was there the unauthorized acquisition, use, or disclosure? Probably. Was there a breach of the privacy rule? Probably, depending on whether or not you used appropriate safeguards or whether it's non-sensitive disclosure. So the question is whether there's a low probability that the data has been compromised, or were you able to retrieve that back before the patient had a chance to look at it? If they retrieved it back before the patient had a chance to look at it, then that's accepted from the breach. That's one of those situations that falls outside the breach. So you look at the low probability that the data has been compromised, see what information was disclosed. If it's simply an appointment without more information, probably okay. If you are a mental health clinic or an AIDS clinic, then merely the fact that the person was there probably is going to be a significant risk. So you'd have to look at those factors. You get the key there? You see the analysis that you have to go through? Okay, and just remember, my advice in close cases, I'd do the report because I think you have a lower risk of the government coming after you and hitting you up with fines if you do that report than if you don't and the patient finds out, turns you in, then they may come after you with willful neglect. By the way, the government is overwhelmed with these things. As far as I can tell, almost all of them in the last 3 years that have been submitted that I know about, nothing else has come up with it. It's been about 2 or 3 years since I've gotten a request from the OCR to follow up. I think they're just backlogged. So I think as long as you respond in an appropriate way and show that you acted in an appropriate manner, that this was not willful neglect, it was in violation of your policies, that type of stuff, they're not obligated to even investigate. They're only obligated to investigate if it's willful neglect. When you do your disclosure, if you can show that it wasn't willful neglect, chances are it's just going to go in some file someplace and nobody's ever going to look at it again. Okay? But if you fail to do the report and the patient turns you in, I don't think they're going to be very forgiving in that situation. All right, let's talk about the HIPAA top 10 list. So this is what you need to take away. I told you, I want to make sure that you don't get hit up with willful neglect. This is what I think you need to do. And by the way, in the materials we provided to you, I've given you a checklist for covered entities about what you need to do to avoid this stuff. So a lot of this is in that checklist that I provided to you. 1, you need to assign and document HIPAA responsibility. Every one of you needs to have a privacy officer and a security officer, okay? That needs to be documented in writing. 2, ensure those officers actually understand the rules. It's really helpful if they read them. Okay. Can't overemphasize that. Alternatively, you can just call me, which is fine too, but it really is a good idea for the privacy officer and the security officer to really kind of know something about HIPAA. 3, review the security rule compliance. Security rule, like I say, that's the big ticket right now. Because if you have a breach, it's probably going to involve lots and lots of people. And the breach is almost certainly going to be because you didn't encrypt the information or you didn't have the required safeguards in place. And the government is pretty critical on that stuff. So pay special attention to your security rule compliance. Make sure that you conduct and document a security risk assessment. If you haven't done that for more than a couple of years, you really need to go back and do it again. And you need to do it on a fairly frequent basis thereafter. Every year, I kind of suggest that every 2 years, I think probably no less frequently than every 2 years that you probably ought to update that. Beware your electronic devices. If you're not doing so, you really need to encrypt USBs, encrypt mobile devices if they're going to store any protected health information on them, encrypt your laptops, because if you do, if you have that lost or stolen laptop, then guess what? You can avoid any reporting. If you don't, you saw all those people who didn't and all the fines and penalties. Number 4, ensure you have the required policies. In the documents I provided you, I've given you a checklist of the types of policies that you need to have in place. The policies required by the privacy rule, the security rule, and the breach notification rule. I've got sample policies for the breach notification rule and privacy rule. If you want a copy of those, give me a call, and depending on the mood that I'm in a particular day, I may give it to you. All right, make sure you develop and use compliant forms. Like I mentioned, those forms seem to morph over time. They may have been compliant when you drafted them or your attorney drafted them, and somewhere along the line they've been changed, and quite frankly, they're just not compliant anymore. Maybe your authorization has been combined with other documents, and therefore it's no longer valid because the authorization can't be combined with other documents. So it probably behooves you to go back there and take a look at those forms and make sure they're still compliant. In the materials I've given you a checklist so that you can evaluate your notice of privacy practices, your authorization, and your business associates. It tells you what you need to have in there along with some additional suggestions. Next, you need to execute your business associate agreements with business associates. Remember, I'm going to send out a client alert, I think, in the next week on this one, because remember the couple of those penalties that came down in the last week or the last 6 months? The covered entity got hit up, not for anything per se that it did, but because the business associate violated it. But the government came in and said, hey, but you didn't have the business associate agreement in place, and therefore you're liable. That's kind of scary. You need to go back and make sure you've got business associate agreements, make sure the business associate agreements are appropriate. You can use that checklist that I provided to you on that. Next, train members of your workforce and document the training upon hiring and periodically thereafter. Why is that important? Again, the government has specifically said, they give the example. You have a situation where a hospital employee decides that they want to go in there and look at information concerning their ex-wife. So they go in there and improperly access the information. In that situation, the government said that hospital employee may have acted with willful neglect, but the hospital didn't, so long as the hospital had the appropriate policies in place and provided the appropriate training. So by training and documenting that, you can show that you did not act with willful neglect. But as the Walgreens case taught us, you can't just rely on that, do training and really not follow up on it. If you think that there are problems, you really do need to take this seriously, or else, you could be a Walgreens situation and have to pay $1.44 million. Next, to use appropriate safeguards, including confidentiality agreements with workforce members. Remember, you don't have to have business associate agreements with your workforce members. You give them to them and they'll say, what's this? But what you can do is have confidentiality agreements with them, your employees, your vendors, those other people like that who may not otherwise do anything with your protected health information like the vendors, but you can still have a confidentiality agreement with them. You've got to use the reasonable administrative, technical, and physical safeguards. And if there is a breach, you need to respond immediately to any potential breach. That means you immediately take steps to mitigate, okay? As soon as you find out about it, you jump all over that. Stop the leak. If it was posted on Facebook, get off Facebook as soon as possible. Don't wait, for a week to get around to contacting your lawyer. Stop the damage now, okay? Retrieve the protected health information. You got the wrong fax to the plumber, right? What do? You call up the plumber. You get that back from the plumber. Either that or get the assurance that that plumber is completely destroyed. I'm not sure I'd do that. I'd probably, if they're local, I'd send an employee out there to get it. And before they got there, I'd make sure I talked to that guy and said, hey, thank you very much. Really appreciate you letting us know. Just so you know, HIPAA criminal penalties are, you can get hit up with up to 10 years in prison and $250,000 fine if you use or access this information improperly. So I'm assuming you're not going to look at this or disclose it to anybody else, right? And they say, yeah, okay. You want to do that. Investigate the facts to determine if there was a reportable breach. Sanction workforce members as appropriate and document that in their employee file. You may have a situation where you've had this employee has had multiple violations. You decide you want to go ahead and terminate them. Your HR department comes down and says, why are you terminating? Well, we had this HIPAA violation. Well, this HIPAA violation doesn't look very bad to me. We haven't terminated others. And you say, well, this is their fifth one. You say, okay, where is it in the documentation? Well, we never got around to documenting it because she's a nice person, and I'm a nice person, and I didn't really want to document it. I didn't want to make her feel bad. Yeah, well, that could make create HR problems for you. Implement corrective action, additional training. If you do have a breach, you need to correct it within 30 days. Now, you can't unring the bell, right? But you can certainly do a bunch of stuff to stop the bell from ringing, including retrieving the information, confirming with whoever got the information that they have not disclosed it further and they will not disclose it through anybody else, that you've taken stuff down from the website, that you've changed your policies, that you've changed your practices, that you've provided additional training. That's the type of corrective action that you may be able to take and avoid HIPAA fines and penalties by doing that. And, of course, you want to document all of the foregoing in case the government comes in there and looks, because not only are you obligated to do that under HIPAA, but you want to be able to show them that, hey, we had a rogue employee, but we did everything that we should, and therefore no willful neglect and no fines or penalties. Finally, if you conclude that there is more than a low probability that the data has been compromised, you need to do the breach report to the patient or personal representative and to the government, and an appropriate, also remember you have to record improper disclosures on your accounting log. So you not only have to do the breach reporting, but you're going to have to also note that on the accounting log. And even if it's not reportable, if it's an improper disclosure, you still have to report it on your accounting log. You just don't have to narc on yourself. Finally, don't do this. Remember, you must mitigate. There is no penalty if you correct a violation within 30 days, and you must give breach notification within 60 days. So you want to jump on this and act as quickly as you can. Finally, we already talked briefly about the insurance, but many companies carry cyber liability or other potentially applicable insurance. If you haven't got that, it's probably worth talking to your broker about that in this day and age, to make sure that you've got cyber liability insurance or otherwise have consciously considered your risks. When in doubt about making the report, again, my advice is to make the report, because I'm lots less concerned about them coming in there and doing the investigation or submitting the report, because they'll probably never do anything about it. But I'm really concerned if we don't make the report and they come in there and disagree and think that we should have made the report, especially if it's situations like lost laptops, lost unencrypted USBs. I think those are the ones you need to really watch out for. Make sure that you document your communications with the insurer if you're going to tender a claim to the insurer. And additional resources, as I mentioned, OCR has a terrific website dealing with HIPAA issues. They've got a wealth of information. I'm actually a little bit leery about telling you about this because you may never call me again for HIPAA issues now that I have told you about this. But I am a lot more fun than the OCR. In addition, we've got a bunch of information on our website, including training videos and things like that, webinars that we've done. It's all free. You can go on there and access that. Got a lot of, as you can tell, I like HIPAA a lot, so I write a lot on HIPAA. It does not impress my kids one bit, but except my daughter, who's a PA, who somehow got the idea that I wrote HIPAA. I don't know where she got that, but she thinks that's pretty cool that her dad's responsible for HIPAA. All right, that is the end of this presentation. Any questions about the HIPAA issues? Yes, ma'am.
When you have your disclosure law, so if you have a violation that you determine is a breach in publication, okay, here's what happened. Are you required to disclose who, I think it was sent to another patient, who that patient was that it was sent to?
No, that would be, yeah, that's, don't want to do that. No, you may have to describe the scope of it. The best thing to do in those situations is pull up the actual rule and take a look at the rule and make sure that you go through the checklist on that. And make sure that you've got everything done. You stay away. You don't want to disclose anything that has to do with the other names of patients. I'm usually pretty vague in the disclosure that I give, including, I will say something like we've taken appropriate steps against or imposed appropriate sanctions against the workforce member, but I usually don't tell them, we fired them or we did this or that or the other. Good question. Anything else? Okay, you guys are all suffering from a sugar coma, right? Question?
So in that case, we can say that the employee appropriately access your records, and they ask the employee's name. So if the employee, I always say that the employee has certain rights and we can't disclose that information, but they can. Okay, so let me make sure I understand. So you've got a situation where an employee improperly accessed the patient's information. You now have to do a breach notification because you feel like, and by the way, just because they access it, you still go through the low probability analysis, and it's possible you might conclude that there's still a low probability that the data has been compromised. But let's say that you access and you decide you have to give the notice. Do you have to give the patient the name of the employee? No, you don't have to, and I wouldn't. All right, I am out of time. Thank you very much. I think we are back to Lauren, right? Okay, all right.
What the states are doing. Each state has very specific requirements, and there's weird exceptions in all of them. You'll have consultation requirements that'll be very limited, so you're allowed to provide, 3 consults a year, and how do you fit within those frames? But telemedicine, I think it's the way of the future, and I don't think there's any denying that states are starting to kind of come around to the terms of, okay, this is going to happen, so how do we accommodate it, and how do we make sure it's effective? How many of you have telemedicine either going on in your facility or utilizing telemedicine in some way? So quite a few, and I imagine that that's grown a lot over the last few years, and I expect to see as more and more of you start raising your hands over the next few years. Telemedicine is considered the provision of clinical services to patients by physicians and practitioners from a distance via electronic communications, and happens in all sorts of ways. It can happen in real time, which is also synchronous interaction, non-simultaneous store and forward. This is more of the teleradiology or telepathology that I was talking about, where you send results away to some other place and they interpret them. And I think that has been common practice for a long time, but people may not have known that. And now it's starting to go outside of the states, starting to go outside of the country, and in a more frequent way that's going on. So people are finding a way to, I think, make a lot of money off of doing that. So what we'll talk about today is the Idaho Telehealth Access Act, Board of Medicine rules that were just published relating to telehealth services, licensure requirements in Idaho, interstate licensure, hospital rules dealing with credentialing as well, and then restrictions on remote prescribing. And hopefully I have it in that order. I think I do. So telemedicine generally is when the originating site where the patient is located at the time of care is treated, the origination of the medical data. So you might take a past sample at this site. The distance side is where the remote practitioner is located, can be in-state, out-of-state, international, and they interpret the results. So Telehealth Access Act. Idaho restricts providers' ability to remotely prescribe and treat. This is the most stringent restriction on the ability to do that. They are very particular about establishing a provider-patient relationship, which is the restriction that comes into place. Telehealth services means healthcare services provided by a provider to a person through the use of electronic communications, information technology, asynchronous store and forward, and synchronous interaction between a provider at a distant site and a patient at an originating site. So the interesting thing about this is all that it includes. So it includes clinical health, health education, home health, and facilitation of self-managed care and caregiver support. So it's very broad, wide encompassing, and Idaho tries to have a little bit of control over all of these different areas while still maintaining, like, okay, we're going to support it, we just want to restrict it. We want to support it but be restrictive in the sense that we're keeping an eye on things that are going on. The Telehealth Access Act allows providers to establish a patient-provider relationship through the use of telehealth, meaning visually and verbally through the use of either some sort of a camera and audio going back and forth, or just the all-encompassing more of like a Skype function. But you have to still be licensed or authorized to practice in Idaho. You must still satisfy the community standard of care, obtain informed consent, maintain proper documentation, and be available for follow-up care. Yes?
So, are we assuming if the provider says this is a one-time deal, then you will not have to establish provider patient if they can document that? There, all the rest of them would be that you have to establish.
Right, so you're talking about a provider who consults with a different provider?
Right.
Yeah, so.
The one-time,
Right, exactly. So the consultation factor is totally different in the sense that you don't have to satisfy all of these obligations. When you're doing a consultation on a limited basis, you're able to just do what you have been doing for years, and that's, you know, one doctor calling another doctor and saying, hey, I've got these weird results, what's going on? So you're fine in that sense. But if it becomes more frequent and it steps into the bounds of being a continuous telehealth provider, then you start falling into this. And that's actually one of the main differences between the states. Some states have a consultation exception and they ride around telehealth. Some states say, you know, consultation doesn't apply to the telehealth restrictions entirely. So it's very interesting. So if you start consulting outside of the state, it's worthwhile to look into it. So the Act provides a mechanism for the establishment of a provider-patient relationship via two-way audio and visual interaction. This is where, I mean, just for commonplace knowledge, you think Skype. That's the automatic thing that comes to mind for me, of course, in a more protected HIPAA-friendly manner. And the provider must still satisfy the community standard of care as if they were having an in-person interaction. And I think what's important to note about that is, like we talked about, this is a community standard of care, it's not a national standard of care. So the provider consulting outside of the state must still adhere to the Idaho community standard of care or the very regional Boise standard of care, depending on what's going on in the state. Provider-patient relationship. If a provider is offering telehealth services in his or her practice and have an established provider-patient relationship, the provider shall take appropriate steps to establish it by use of two-way audio and visual interaction. This is again reiterating how important it is to make sure that that relationship is established. Where you cannot do that is with the electronic prescribing, and we'll talk about that a little bit later. Exceptions. So pre-existing provider-patient relationship. So you've seen this person at the facility before and it's the same provider and maybe they need to consult over some sort of issue that they're having as a follow-up care, in terms of follow-up care. Between a provider and another provider concerning a patient whom the other provider has the provider-patient relationship. This gets into the consulting exception that you were talking about a little bit earlier. And that as long as that provider providing the care or has the provider-patient relationship. And between a provider and a patient where the provider is taking call on behalf of another provider. So this would be if you had a provider who was out of the country and the provider was stepping in for call duties and the patient needed something but was in a rural area, the substitute provider could come in and provide the same telehealth access, even though that relationship hadn't been formally established. And then in an emergency. So evaluation and treatment. Prior to providing treatment, including a prescription, provider has to obtain and document a patient's relevant clinical history and current symptoms. One thing that's important to note is that you cannot just use a formulaic questionnaire and say we've established a relationship through this use of the questionnaire and I can now prescribe that way. It's not formal enough to establish that relationship, and it's not considered a successful evaluation under the statute. You still have to maintain the Idaho standard of care in all of those facets. So I think the one thing to really take away from this is that if you're thinking that you can just have somebody input symptoms onto some sort of formulaic questionnaire, it's not going to be sufficient to establish the patient-provider relationship, nor is it sufficient for you to establish what would be an initial evaluation. So prescriptions, and this is, I think, Idaho's most stringent restriction on telehealth. A provider with an established provider-patient relationship may issue prescription drugs within the scope of the license according to applicable laws and regulations, but you cannot prescribe a controlled substance unless in compliance with federal statutes. You also have to apply with the community standard of care. And you cannot prescribe any telehealth. You cannot prescribe through telehealth services for the purpose of an abortion. Medical records. Any provider offering telehealth services must still be in compliance with HIPAA. There's no way around HIPAA. You always have to make sure that you're in compliance with both HIPAA and HITECH. And I think Kim touched a little bit about some of those ways to make sure that you're encrypted in data. There's a lot of services out there now that will ensure that your communication through a portal is encrypted and protected in all formats, and that it's a secure connection between the two computers. So if you're really looking to establish a strong telehealth practice, that's something that you should look into, and the types of software programs that are out there to help that. Records must be accessible to other providers in accordance with rules, laws, and regulations. This comes to be kind of important because one of the requirements under the telehealth regs is that you have to be available for follow-up care or be able to advise somebody as to the location where they should go for follow-up care. So those records need to be able to be transmitted to whoever would be providing that type of care. Informed consent. I probably haven't said that enough today. Important to have informed consent. So the follow-up care and additional information to patients who elect to use the telehealth services. One thing to keep in mind is that if your provider or your facility is really making sure that telehealth is functioning properly, you want to be sure that whatever is being treated via telehealth is the type of work that should be done via telehealth. A lot of times you'll see that care has to be done in-house. There has to be certain types of diagnoses or tests that are performed in the facility themselves, and you have to have a place where you can direct them to go. Be familiar with and have the medical resources available and emergency resources that you would know to direct them to. In rural locations, this is particularly important. If you're treating somebody in a rural location via telehealth, you want to be sure that you know where to direct them to go, where the closest hospital might be or emergency department for them to access. So the board regulates telehealth, but you also have to really think through all those other things that could come into compliance because you're still worrying about the informed consent. You also have criminal issues that could come up. You still have typical malpractice issues that could come up. You want to be very conscious and make sure that you're complying with all of the rules and regulations. Otherwise, the provider will absolutely be subject to potential issues with the licensing board. Provider-patient relationship. So these are the rules that were recently published by the board. The provider-patient relationship requires verification of the patient's location and identity, disclosure to the patient provider's identity, location, phone number, Idaho license number. And this is pretty thorough. I mean, if you think about it, in order to establish that relationship, you're making sure that these things are all adhered to every time you're getting on the telehealth mechanism, however you're transmitting the information back and forth. You have to, for sure, get consent, appropriate consent, following disclosures of models and treatments and treatment methods. Something to kind of think about is there's a lot of there's a lot of regulatory bodies that are putting out telehealth forms now and kind of talking about the appropriate standards of care to be used in treatments provided by telehealth. The other day I ran across one, and I don't think this is appropriate at all, but it was talking about obstetrics telehealth procedures, which to me, in so many different ways, I was like, really? That was what you really wanted to go for here? But I'm sure there's uses for it in all facets of medicine. But think through some of the forms before you put them into practice is what I'm trying to say. If it seems a little bizarre to you that would be okay to do via telehealth, something to keep in the back of your head. Common sense still applies in all of those situations. Special informed consent for the use of telehealth technologies. You have to acknowledge that there is some inherent risk in any form of electronic communication. There's always a possibility of a breach, whether we like it or not. We can't prevent all of that from happening. Provider selection. So there's some telehealth issues with you get on, it's kind of like, it's almost a little, I'm trying to think of there was a game at one time where you could sign onto Skype and you just flash to having another person on Skype across from you and you had no idea. It was like almost a Russian roulette of asynchronous communication. But you have to be able to select the provider who you're going to talk to on telemedicine. So it's important to keep in mind that the patient still has the right to consent to whoever his or her provider is going to be. Can't be selected for them. Standard of care, again, Idaho Community Standard of Care, and it's the provider's responsibility to determine what that is and the extent of the care that can be provided via telehealth. If the patient's symptoms require physical examination, lab work, or imaging to diagnose, provider cannot diagnose through telehealth until such services are provided. If you need lab work done, don't continue on with the treatment protocol through telehealth. Make sure that patient gets into a facility, gets the lab work done, and then continue. And if it's an emergency situation, of course, send them exactly where they need to go. Informed consent, evidence documenting appropriate patient-informed consent must be obtained and maintained at regular intervals consistent with community standard of care. Curiously, regular intervals has not been defined, and it's something that I think we will probably get more information about as telehealth continues to be used, whether that is every single time you talk to a patient, whether it's a matter of how consistently you are seeing that patient via telehealth. Those are all important things to kind of keep at the forefront, and it'll be interesting to see what the rules really come down to mean. At a minimum, you have to include verification of patient, provider, and provider's credentials. The provider has to determine whether it's appropriate for telehealth, and then the security measures that are taken must also be disclosed in the informed consent. And that's, I think, a challenging one to explain because I think a lot of times you don't know, right? It's like a secure portal, but do you know what's encrypted? Do you know what's password protected? And how you can authenticate the person who's on the other end. Those are all things to have probably at the ready when you're documenting informed consent. And then again, the potential information loss for security breaches. Anytime you're using online services to provide telehealth, you're at risk. There's always somebody who could get into the portal. There could be all sorts of security issues. So that would actually be, if you're providing telehealth services, that was one thing that I actually did see a lot of cybersecurity insurance when I was in Texas dealing with that. It was something that pretty much everybody had commonplace, and they documented that in a lot of the informed consent stuff that I looked at. So I think that's I think you had asked about cybersecurity insurance, and that's probably a place where I would think about it. Licensure. I actually love this sign. I think it's great. That and the other one is Idaho home to lots of lost, beautiful, single young women or something like that. That's my other favorite sign. I couldn't find that one for this though. So licensure. Licensure is incredibly important. The telemedicine provider absolutely has to be licensed in the state of Idaho. Otherwise, you're subject to practicing without a valid state license, and you can be subject to criminal or administrative sanctions. You could lose your liability insurance, and there could be a risk of no reimbursement. Everybody wants to get paid. It's important. So at your originating site, there's no liability insurance. If your provider is not licensed at the originating site, you have no liability insurance for that provider. You also risk loss of reimbursement. The facility could also face licensing problems for not having their providers on site adequately licensed, and which could lead to all sorts of provider problems down the long run, and we'll talk a little bit about those down the road. But you also could be subject to negligent credentialing liability, and credentialing, I think, is one area that'll be very interesting to see as more and more hospitals continue to participate in telehealth. So state laws generally require that practitioners be licensed by the state in which the patient is located at the time of service. This is changing, though. States are seeing a lot of flux in terms of their telehealth regulations, and they're having to go back and look at these previous licensure requirements that they had and see how specific they are. Some states grant temporary licenses. Some states don't grant licenses to out-of-state providers unless they're there practicing themselves. So it's really interesting. So if you're ever looking for a specific state, don't hesitate to reach out, because it's worth the research effort to figure it out. Sometimes you'll call, I had to call a few states, southern states in particular, and I think there's a lot of confusion as to what you're asking for. So I was asking particularly about pathology. You know, can we send a sample out of Texas? Can we receive a sample from outside of Texas, interpret it in Texas, and send it back? And a lot of the response was, why would you want to do that? You know, you're like, well, I think a lot of people do it now. But people are catching up, and it'll, I think, continue to change, and people will grow to understand that it has to be more of a national practice. And it's helpful for a lot of practitioners who may not have the support that they have in their state. So if you have better equipment in a bigger state, why would you hesitate to send some of your past results outside? But Medicare and Medicaid do require licensure, and there are, of course, consequences for all of that from both the state side, Medicare and Medicaid, and oftentimes the Board of Licensing. So in Idaho, to practice medicine means to investigate, diagnose, treat, or prescribe for any disease, ailment, injury, or other condition by any means. And sometimes you'll see there, in a few other states I've seen, where it says analyze too, which is interesting because that brings in a whole other level of medical practice. But the unauthorized practice of medicine is a felony, and you can be fined up to $10,000, 5 years in prison, and have adverse action against your licensure. Very serious results if you're not cautious. The consultation exception is in effect, and it's very interesting. So again, no specific number, and the interpretation as to what consultation means and how frequently it can occur in a year, there hasn't been any specific finding on that, and how many other physicians can be involved, and it's very interesting. So if a telehealth provider contracts to provide services for a hospital, such provider generally has to be licensed in Idaho. It's worthwhile to look into that before starting to practice telehealth in the state. Board of Medicine interpretation regarding reading of radiologic and imaging studies. So basically the board came down saying, yes, you have to be licensed, even if you are interpreting radiologic images and you are doing any sort of imaging studies. Those all you have to be a licensed practitioner unless you're doing a consultation. So kind of a little cyclical logic there to me, because I would be like, well, why wouldn't we qualify for the consultation exception if we're just doing it on a limited basis? A lot of the threshold question is, how frequently are you doing that? Are you formally licensed? Are you formally contracted to do those interpretations? Rendering a diagnosis for inclusion in the patient's medical chart is kind of where they came down for pathology, and I looked into this before I kind of moved back. So Idaho's pretty firm, like we do not permit an out-of-state provider to interpret pathology results and then send them back into Idaho, unless it's, again, in that consultation exception, which is undefined. So for Idaho Medicaid reimbursement, the telemedicine physician providing care must have a current Idaho licensure. There are some exceptions, and there is a huge push to have an interstate licensure compact. How many of you have heard about the interstate licensure compact? Oh, it's great. I'm super excited for it. It's not here yet. I'm hoping that it'll be here soon. But there are several states that are included in that, and I'll talk a little bit more about it soon. But there are some other exceptions, and those are for Individuals who are in the military, working in the VA system or public health services, that exception only applies if you're still practicing in that same system. So if you're at a VA hospital in one state, go to a VA hospital in another state, you can't leave the VA to go provide the same treatment. Nurse licensure compact allows for multi-state licensure for nurses as well. So telehealth provider in another state to Idaho, ensure that the outside practitioner has an Idaho license or is consulting with the Idaho practitioner and does not set up a practice in Idaho or contract with a hospital to provide services in Idaho. Once you hit that, then you're definitely outside the scope of the consultation. Telehealth provider in Idaho to another state, check the laws of that state, and like I said, it varies. Hospitals, in all cases, healthcare professionals must be legally authorized to practice in the state where the hospital is located. When telemedicine is used and the practitioner and patient are located in different states, the practitioner providing the patient care service must be licensed or meet other applicable standards that are required by the state or local laws in both the state where the practitioner is located and the state where the patient is located. So interestingly enough, federal defaults to state and local laws there. So again, just continue to check wherever it is that you're looking into telehealth options. In-person, some medical boards require an in-person physical exam in order to get licensure, in order to prescribe or render treatment prior to making a prescription to a patient. This is usually governed by the Medical Practices Act and statements of medical boards. And this website is actually a pretty good resource for what internet prescribing laws are in place. Generally, people started enacting these types of laws and regulations because there was a huge push to just basically be an online giant pharmacy prescriber and issue prescriptions for all sorts of things that hadn't been formally examined for or adequately prescribed. So Idaho law regarding remote prescribing, prescription drug is not valid. A prescription drug order is not valid unless it's issued for a legitimate medical purpose, and it includes a documented prescriber-patient relationship, including an evaluation adequate to establish diagnoses and identify underlying conditions or contraindications to the treatment. So establish that patient-provider relationship prior to prescribing online. A lot of times I think of, if you've gone in to see your physician pretty regularly and you need a renewed prescription for something, that's totally fine. That's not what the statute is intended to prohibit. It's intended to prohibit these online just mass pharmacies from dispensing medicine to people who have never been to see their physician. So treatment, including a prescription drug order based solely on an online questionnaire or consultation, does not constitute a legitimate medical purpose. It's unlawful to prescribe drugs to individuals without a prescriber-patient relationship. And you can be subject to board disciplinary actions. There are some exceptions. Newly hospitalized patient, initial admission orders, writing a prescription order for a patient of another prescriber for whom you're taking calls. There's starting to be some similarities between these two areas. And then writing a prescription drug order for a patient examined by a physician assistant, advanced nurse, or somebody else who's licensed with whom the prescriber has a supervisory or collaborative relationship. And then a short-term basis for a new patient before the patient's first appointment. Opioid antagonist, emergency situations, epinephrine and auto-injectors, and if there is a diagnosis of an STD, you can online prescribe to that person's partner. Okay, Interstate Medical Licensure Act. So these are the states that have enacted the Interstate Medical Licensure Act. Yes.
What's an exception? Oh, never mind. I thought you said that they should write it.
You're like,
there's no
you're like, how'd they slip that into the legislature? Yeah, nope. There would have been all sorts of interesting things coming out of that. So the Interstate Medical Licensure Act, these are the states that have passed it. And there's I love the description on the website. So it's a commission of representatives from states participating in the compact have begun formally meeting and is implementing the administrative processes needed to begin the expedited licensure process. But licenses have not yet begun to be issued. So this is great to me because there's all these states that have already passed the act itself and are like, oh yeah, we're committed. We don't actually know what the standards are, but we're here, we're ready. So I'm hopeful that it'll be soon, and I think it'll be really interesting to see what they come up with. And the goal is to really make licensure really efficient between all of the states and to promote shared information and access to medical care in rural areas, both needs that I think every state is addressing and dealing with in one form or another. And so theoretically, when one of these individuals is seeking interstate licensure, you would designate kind of like a home state, and then you would be able to almost waive into these other states is the idea behind it. And you're still subject to each individual board of medicine. So this is interesting because for me, we're kind of moving the same direction in the legal field, equally as slowly, but I think the idea is that these professional licenses there's so much national work that's going on and being done, I think, in both the medical and legal fields, that trying to facilitate as many people being able to service the areas that they need to provide. Credentialing and privileging. So states usually require credentialing of practitioners to provide services at hospitals or other facilities. State statutes or licensing regulations are in effect. Medical staff bylaws require credentialing. It's all very state-specific oftentimes for some of the credentialing rules, and individual credentialing for telemedicine can be very problematic because you might not know the number of providers who are providing the telemedicine services. Teleradiology is a particularly great example. You don't always know who's interpreting those images. And the facility may not be qualified to assess competence of telemedicine providers through internal credentialing policies, especially if you don't know who the person is. Pretty good indication you might not be qualified to know who it is. Idaho hospital rules, there's not an explicit provision addressing telemedicine credentialing. They contemplate individual credentialing. Medical staff members must be qualified for privileges. Privileges are granted only on a basis of individual training, competence, and experience. And the process must include application agreement to comply with bylaws and delineation of privileges. It must include board, administrative, and active medical staff, and reappointment every 2 years. Those are still applicable. Medicare conditions of participation allows credentialing by proxy for telemedicine providers. Hospital may accept credentialing done by a distance site if it meets certain standards. And there must be an agreement between the hospital and either the distance site hospital that participates or the distance site telemedicine entity. So credentialing by proxy for telemedicine is totally fine for conditions of participation, but if a practitioner provides non-telemedicine services, the hospital must credential practitioner in a traditional manner. Many state laws, regulations, and bylaws allow facilities to grant temporary emergency licenses. Unclear how that coordinates with telemedicine conditions of participation. So you may need to update your bylaws to address telemedicine, especially if you're just starting to provide it or use it. Things to think about are geographic proximity. Will you be doing all intrastate or will you be doing interstate telemedicine? Categories of staff members that might need to be addressed, the type of privileges that can be granted, do you need to conduct credentialing? And CMS survey process requires a review of medical staff bylaws to verify your compliance. That was fast, but I wanted to make sure I got done relatively close on time, sorry. Anybody have any questions? Well, it's a new area. There's lots to learn. I'm learning a ton still, and I know I'm sure Kim feels the same way. But if you have questions, chances are that everybody has similar questions about this area, and so don't ever hesitate to reach out. It's just as interesting for us to look into them. So with that, I'm done for, yeah, okay. Okay. I think I can, there we go. Here we go. Thanks, Lex.
clicker working still?
Yes, you changed the battery.
See if I actually end up moving around. Quick, leave while you still can. Thanks. All right. Can you all hear me okay? Is this thing good? Great. So my name's Matt Linton. I am an OSHA lawyer, so I know this is a little perhaps out of the ordinary for some of you to be thinking about OSHA all of a sudden, but there are some interesting things that we thought we might want to tell you about and maybe give you some food for thought on some of the regulatory issues that healthcare entities, in particular inpatient healthcare facilities, are facing with respect to OSHA. So one thing to keep in mind, and I guess, you know, usually when I ask people, a few hands go up, but has anybody had any experience in the recent past with OSHA at all in this room? What? Okay, sure. No, that's actually that's pretty common. So great, one, yay. Don't mean that, sorry. So one thing that's to keep in mind about OSHA is that the agency is inherently political, and the OSHA inspections and the attention to, in particular, your industry will be driven partly by political considerations. And the big one that I think everybody will remember is the Ebola issue that came up, you know, about a year ago. And the new one is Zika virus. And so, you know, these things, as these kind of public health scares pop up, your obligations as employers of medical providers become more of a focus for the agency in terms of protecting your employees from these types of issues. And the Ebola issue was really fascinating because you know, I think a great number of healthcare providers were truly caught off guard about how to properly protect their physicians, nurses, and staff, and you saw this kind of haphazard, crazy response with CDC saying one thing, and you know, OSHA was out there saying other things, and then you had local hospitals going one direction. And my own father is an emergency room physician, and he would send me pictures, for example, of the guidance that would change almost daily of the personal protective equipment that they were supposed to use in the ER, and it was really kind of sadly, you know, just scary. And I think hopefully things have improved. But so, you know, OSHA is there. It's always hanging out there, and I think there's an increased interest, and you will see based on some guidance that came out last year, where the agency really is focusing more on the healthcare industry going forward. One of those reasons, the reason that it's focused is while fatalities are relatively low in terms of the incidence rate in the healthcare setting, injuries, just pure injuries, are actually quite high in the healthcare sector. And you can see up here that, you know, kind of the summary is more than 1 in 5 cases reported by private industry employers in 2013, this is really actually the latest data, occurred among healthcare and social assistance industries. These injuries they're non-fatal. A lot of them are musculoskeletal injuries, but nonetheless, this is on the radar of OSHA. They are paying attention. And if you look at, again, the distribution in the private industry sector, healthcare and social assistance is quite high. So this is guiding the agency's action and taking a closer look at you guys. And nursing assistants, when you look up here, compare that, so 44,000, you can see that compares to laborers, freight, stock, and material movers. You know, it's a pretty high number. And heavy tractor trailer truck drivers. So nursing is a dangerous profession, if you didn't know that already. So, you know, what is safety and health law? Generally, it's accomplished at the federal level through OSHA. Here in Idaho, you are a federal state. There are other states that implement what are called state plans that essentially implement the federal regulations and sometimes do a little bit more. But with a few exceptions, all employers fall under OSHA, except for the mining industry in particular, which has its own agency. But the regulations that apply are strict liability regulations. And those, the thing to think about would be speeding tickets, right? It doesn't matter why you broke the law, it just matters that it happened. So the excuse doesn't matter. It may help in the penalty that would get assigned, but the fact of the violation is what counts. So you can see that the state plans, the ones in white are federal jurisdictions, the ones in blue are state plans. Not surprisingly, California has its own set of, very fascinating regulations. So, why is this not working? Oh, well, I'll just click on here. No, nothing's happening.
I'm not sure, Jim.
No, I don't think so. Thank you. There we go. All right, so here is another thing that will change perhaps how often you all see OSHA. And that is last January, the reporting requirements changed and are now much more stringent in terms of what employers have to report to the agency. So all work-related fatalities, and that's not a huge surprise within 8 hours, but all work-related inpatient hospitalizations, amputations, and losses of an eye. That also has to be reported within 24 hours. And obviously an inpatient hospitalization, I mean, that's not a huge threshold in terms of an injury. Kind of an odd one, just as a weird thing to think about, there's something called degloving, where you lose the skin on your hand. That's not reportable. I mean, it is as an accident, but not immediately, so I don't know why. Seems like a terrible injury. But, this quote, it's kind of a fun one. And in fact, just this morning, this came up because we had a client, and it wasn't in the healthcare setting, but a client that was, kind of thinking, well, maybe OSHA, they're going to be my friend a little bit here. They seem really nice. But that's what they're trained to do, right? So, yeah, they're there to help ensure workplace safety. But they actually go through training. They go through limited sort of interrogation-style training. They learn how to talk with people, how to walk down the hallway and be like, oh, there's just one other thing I wanted to ask you about to get this kind of information. You must always keep your guard up. They're not the enemy, but they have a purpose, and they're there to find violations. So, one thing that comes up, and we'll talk about it a little bit, is responding to document requests. And a lot of people have this tendency to just kind of hand things over, and that's dangerous. So, big question is, should I let them in? So let's say, somebody calls you and they say, hey, somebody from OSHA's here. What do we do? Do you let them in? Well, technically, you can say, take a hike and demand a warrant. That's something that we never recommend doing ever unless there is some really compelling reason, because what they will do is they'll go get their warrant, and then they're going to come back with a couple of other inspectors really pissed off, wondering why it is that you made them get a warrant and what do you have to hide. So, generally speaking, cooperation is good, and find out why they're there and just, work through the issues with them. The healthcare industry faces another kind of conundrum here because there aren't very many particular standards that apply. One that I'm sure you're all familiar with is the bloodborne pathogen standard, which is came about after the HIV scares in the 1980s and needle sticks and everything else. And so that's very focused and well developed. That also obviously applies to Ebola, and it's the big one that's going to apply to Zika virus as well. But aside from that and a few other things, healthcare falls under what's called the general duty clause. And this is incredibly vague and very, very broad. You know, an employer, so this applies to any employer, but an employer has to protect their workers from any hazards that could potentially cause death or serious physical harm, as long as there was a reasonable means that existed to eliminate or reduce the hazard. Common examples would be workplace violence or ergonomics. Those are regulated under the general duty standard. However, other ones, for example, tuberculosis focus by the agency, they attempted to develop tuberculosis regulations. It never happened. So now OSHA's regulation of tuberculosis exposure within the workplace falls under the general duty clause, and as a result, what are they looking to? Well, they're going to look to the CDC. They're going to look to National Institute of Health. They're going to look at these other agencies, but here's the problem, right? Those agencies, they're not law-making agencies. They haven't gone through rule-making proceedings. Nobody's had a chance to comment, for example, generally speaking, on CDC guidance on X, Y, and Z. So from an employer's perspective, you know, very few people probably at the CDC are worried about how might a hospital comply with this guideline if OSHA were to use it as a basis for a general duty clause violation. So it's very hard to actually comply, and it's somewhat of a moving target. But that being said, you know, just kind of a little background for you all. What is an OSHA citation? Okay, you know, you mentioned you got one for SDS reports. Those are safety data sheets. So generally, you have to maintain safety sheets on any toxic substance or harmful substance that your employees could be exposed to, and if you don't keep those, it's a violation. So what OSHA has to do is they have to describe the violation, they have to reference a specific regulation or the general duty clause, and that would, the classification falls in something called either other than serious, or God forbid, willful, and that kind of connects a little bit to what Kim was talking about in the context of some of these HIPAA breaches, where, you know, when you get into willful territory, it's scary, and we'll talk about it. But you do have the ability to contest these things. There's some specific requirements, but really, you know, once you get an OSHA citation, you know, you're going to have to spend a lot of money to try to get out of it, and usually some part of it is going to stick to you. Other than serious violations are generally going to be those SDS violations. They're going to be up to a potential penalty of $7,000. Not a huge individual penalty, but if you get a bunch of them at once, it starts to add up. Where you really can have issues is what's called the abatement process. So OSHA requires you to take certain actions to, quote, abate the citation and make it go away. Well, that can cost, depending on the circumstance, you know, potentially hundreds of thousands of dollars to change processes, train people, do all sorts of things just because you got some small violation. Serious violations, the reason those are problematic is not just the fine, and a serious violation is where an employer had knowledge of the condition or could have known with reasonable diligence a condition that could cause death or serious injury. Well, if an entity just has one serious violation and then within the next 5 years gets another one for the same or similar regulation, you can get what's called a repeat. And a repeat here can go up to $70,000. And they might start to also think, was this willful? I mean, they dealt with this before, they should have known about it, and they're going to really dig into the facts to see, did they really have some intent or deliberate process that caused the entity to violate the standard, and that can form the basis of potential criminal charges, which nobody wants. So what goes into this consideration of negligence, or of whether it's serious or other than serious, really kind of comes down to negligence, okay? And what is negligence? It's what did I know, when did I know it, and what did I do about it? Again, similar to some of these concepts that, you know, with HIPAA, right? You know, if you start to have some knowledge of something and it's problematic, the negligence level starts to tick up. And then it comes into, what did you do? What's OSHA looking for? Action or involvement of management personnel. Did management observe or direct or approve of the action? And should management have known? That's another, you know, really difficult one, right? Should you have known? So, focus areas. So I just added this. This is a lecture I kind of do from time to time, and Zika is a new addition. So just, I think last week, OSHA and CDC issued a combined guidance document that covered, among other areas, healthcare and laboratory workers. Take a look at this little document. It's not particularly surprising what's in here. Most of it is basically reminding folks to follow standard infection controls, use of appropriate PPE, ensuring that laboratories meet appropriate biosafety levels, proper engineering controls and standards. But, you know, here's the thing. With Zika virus hanging out there and we're entering the summer where some mosquitoes are going to start to come out, we don't know how far this thing's going to spread within the U.S. Will it make it up here to Idaho? I don't know, right? Probably a good idea to remind your employees in the context of all needle sticks and bloodborne pathogens that, hey, this is another thing to watch out for. And if, you know, if your patient is coming in with symptoms that may resemble Zika virus, it's just one more thing to be aware of as a part of that analysis process in terms of how we're going to handle this patient. And if you do have a needle stick, you know, there needs to be a discussion about whether or not, for example, is it a, I mean, we've seen in Brazil, is it a young woman, is it a brand new young medical provider that is of childbearing age? And, you know, we're seeing that they're saying possibly up to 2 years that they should not have to, that they should avoid getting pregnant. So, you know, there's some real issues there from the employer's perspective, and that's what OSHA is going to look to. They're not going to expect you to prevent Zika virus, right? They're not going to expect you to have perfection, but they will expect your, you know, your companies, your entities to have this dialogue, to have maybe a little extra level of training and reminder to your folks about what to look out for. There was also, last July, some specific guidance that OSHA issued, mostly in light of those statistics that are showing these fairly significant injury rates within your industry. This guidance applied directly to inpatient healthcare, and it was fairly detailed. Who does it apply to, which is a good question. You know, hospitals and nursing homes. Well, what does that mean? It's this crazy long definition from the NICS of what a hospital is. You could read that at your leisure and see if you can make sense of it. It doesn't make all that much sense, frankly, and it's definitely going to be a little bit of a slippery slope in terms of what OSHA might actually consider a hospital. Same thing for nursing homes. It's this long definition. I'm not going to read it to you, but technically, if you think in your mind generally hospitals and nursing homes, that's who this guidance applies to, but the standards apply to everybody in the healthcare industry. Just, you know, simply because OSHA issues guidance targeting inpatient facilities does not mean that that same guidance wouldn't apply to a healthcare provider that's not technically a hospital or nursing home, but nonetheless it encounters the same hazards. So what are those hazards that OSHA identified? Number one is musculoskeletal disorders. Why that is a picture of Ebola, I don't know. Something got messed up on the slide there. And this, you know, they call it MSDSs, and really relates to resident handling, particularly in the nursing home side or in the hospital setting. You get a lot of back injuries, things like that. Workplace violence, surprisingly enough, I mean, this is a huge issue. Maybe it's not surprising because you all do deal with some of this stuff, but and we're not, you know, this is both patient violence to provider and employee to employee threats or incidences of violence. And bloodborne pathogens is the other one, as well as tuberculosis and slips, trips, and fall. Let's do this again. So, there we go. Some data. OSHA conducted 1,100 inspections of nursing and residential care facilities between April 5th, 2012 and 2015. April 5th, 2015. Ergonomic stressors evaluated in 596 of those inspections generated 192, quote, hazard alert letters. The government loves the acronyms. They call those EHALs. To employers, 11 citations. That's a pretty small number of citations, and again, general duty clause. However, one thing to keep in mind, a citation under the general duty clause has to be serious. So OSHA can only issue a serious citation under the general duty clause, and as I said, that can form the basis for a repeat or a willful, which is then going to take up to $70,000 and look at criminal later. So even 11 serious citations within the next 5 years now, those folks, I mean, this is the most common area, right? Musculoskeletal injuries. So it's going to be a serious problem for those entities now to ensure that they do not receive another musculoskeletal disorder, or not disorder, excuse me, musculoskeletal injury citation within the next 5 years. That's going to be really hard. It's going to cost them a lot of money. Workplace violence, another agency that OSHA looks to all the time is NIOSH. It defines workplace violence as violent acts including physical assault, threats of assaults directed toward persons at work or on duty. Healthcare sector, 13% of the injuries and illnesses that were the result of violence, in the healthcare and social assistance sector, 13% of the injuries and illnesses were the result of violence. And the rate increased for the second year in a row to 16.2 cases per 10,000 of full-time workers. So basically this is ticking upward again, which has caused OSHA to pay attention to it. You probably would not know that the current head of OSHA, of course all of this is going to potentially go out the window with the next president, but the current assistant secretary that runs OSHA is an epidemiologist. So this guy lives and dies by data, statistics, and evidence that he looks out into the world, and that's what's driving enforcement for OSHA currently. Bloodborne pathogens. It is one of the most frequently cited standards, and it's going to be an area that deserves continued focus. It's the obvious area. It's always something that OSHA is looking for. And the first thing that they will do when they inspect your facility will ask you, where's your bloodborne pathogens policy? Where are all your training records pertaining to that policy? Where are all your incident reports pertaining to bloodborne pathogen violations, et cetera, et cetera, et cetera. And keeping your ducks in a row with respect to these obvious focus areas is key. Tuberculosis is another area where, I'm no healthcare provider. I thought this died in the 1800s. This is apparently a huge problem still, and in particular in nursing home facilities. And so this area is hot on OSHA's radar. And as I said, there are no specific standards. So it's a little bit vague, a little bit funky. There is some guidance that's out there. They do follow generally sort of CDC guidance for how to control tuberculosis, but it depends on the facility. Not every facility is even going to have the capabilities of negative pressure, air containment rooms, these sort of things, and that's a serious consideration. So if you get a patient in and you think perhaps this might be somebody with tuberculosis, they need to be, sequestered. They need to be put in the proper place. Your employees, it's not just for the other patients. It's for your employees and your medical providers to ensure that they are protected. Slips, trips, and falls, an obvious one, happens all the time. One of the most common areas, and it's not just for compliance purposes, right? Because these basic little small injuries account for 68% of all cases reported with days away from work. So this is costing your business's money to have where people are out, even if it's a couple of days. It's something to focus on. Another big one, MDROs, multi-drug resistant organisms, right? Yeah, something like that. So like at MRSA and other similar issues. And this is another area that OSHA. This is like easy thing for them to pick at, right? Because they know this is an issue, and they're going to look at policies pertaining to this. Again, instant reports, that sort of thing, when they come in. Now you're wondering probably, well, you keep saying they're going to look for this, but we've never seen them. Where are they? OSHA doesn't seem to bother us very much. Well, that may start to change a bit. And before I kind of get into this part, where OSHA has really changed its approach in the last year to 2 years is on the whistleblower side. So what they've done, so OSHA is perpetually underfunded. They don't have enough inspectors to properly look at every workplace. I think the numbers are something like if a particular OSHA area office had to inspect every workplace in their region, it would take them 145 years per office to cover all their employers. It's not possible. And the federal government's not giving OSHA any extra money anytime soon. So what they've done is they're trying to empower individuals, in particular your employees, to self-report violations. And this is a huge initiative, and I would say right now about 30 to 40% of the work that I am doing occurs because somebody anonymously called OSHA and made a safety complaint. And it's been in the healthcare side, it's been really in all industries. But what, you know, there is an enormous amount of communication that is going out to people right now about their whistleblower rights. You can go to whistleblower.gov, and it's all there. Okay, and OSHA actually enforces 22 different federal statutes for whistleblower provisions. But it's anonymous, it's easy, and here's another problem. What's happening is, while I think it was a good idea that, hey, let's just empower employees to tell us when they think there might be a problem, and then we'll follow up on it. And that way, it's like everybody's an inspector, right? Because we can just send them all out there. Well, first of all, aside from just people that, you know, okay, some people are going to maybe make a call and it's not real and it's okay, and OSHA will maybe, you know, do an inquiry and close it. But where we're really seeing this is terminated employees. All the time now. It is becoming seriously problematic, where we have, you know, somebody will be terminated for cause for a very good reason, and the next day, literally the next day, we're getting a call from OSHA saying that they're going to be going to do an inspection based on the alleged retaliation for raising a safety complaint. And that's the way this works. So the employee says, look, I told my boss that this was terribly dangerous and somebody was going to get killed, and then I got fired. So a lot of the time, people are truly inventing these stories. And yet, OSHA has a policy right now where they will follow up on 100% of all whistleblower complaints. So, I mean, even for, I'll give you a small business example. I'm working with somebody right now who is a small catering company in Denver. They fired an employee who was not a good employee, and she called the OSHA Whistleblower Protection Program. She called every possible agency, state and federal, she could. And you have a small business run by 3 people that has been dealing for about a month now with an inspector from some state or federal agency talking to them about everything from wage and hour violations to OSHA violations, and all of it's not real. There's nothing to it. But, you know, government inspectors will come because they have to follow up. That's their current policy. So, go ahead, yeah, please. Nope, not at all. And in fact, if she were to ever apply back to that company and she were not hired, very likely OSHA would follow up with a retaliation-based complaint saying you didn't hire her because of her previous safety complaint, because that's protected activity. No, the protections for people to report are huge. There's absolutely no penalty. In fact, generally speaking, well, when they raise a whistleblower complaint, you know who they are because they're specifically saying, you know, I got fired for X. But when somebody complains anonymously, the agency doesn't tell you who they are. And in fact, if the employer tries to find out, that can be a violation in itself. You're not even, you know, supposed to know. So, yeah, there's really no bar on somebody's ability to just simply, I mean, it's an 800 number. It's on their website. It's so easy to phone something in. So I'm basically at the end. So, yeah, you know, really the one thing I wanted to get covered before I conclude, which is how do you prepare for this? One is just doing, obviously, self-audits in terms of looking at your policies and procedures. OSHA's telling you their focus areas. Take a look at your policies with respect to those focus areas. Take a look at your training with respect to those focus areas. We recommend developing an OSHA response plan. There's nothing particularly magical about it, but it's appointing a person, kind of like, again, in the HIPAA thing. It's like having a privacy person. We recommend having an OSHA person so that in the event, not only that, can that person kind of help guide. A lot of big entities will have a health and safety person, but we recommend appointing some person who will be the point person should OSHA either show up for an inspection or even just call with an inquiry, having one person be the source of communication is very helpful and can really make things go over smoother. Again, training. As a part of OSHA training, you're required to also train your employees in a very detailed way on how they can make these whistleblower complaints to the government. So you get to train them how to call in your issues. But another thing is, and this is not typically an issue with hospitals or any sort of medical provider, but building a safety culture. Empowering your employees. Your employees are much less likely to want to go call the government and say that you're doing bad things if they believe that the company, that the entity actually cares about their safety. They're much more likely to go talk to their supervisor. They're much more likely to try to take a more collaborative approach and feel like, hey, we're all in this together, than if they feel like these people just don't care. And you saw this. I mean, there was numerous lawsuits filed by some of these nurses that were affected by Ebola, basically saying these people just didn't care about us. They just threw us in this room, and, that was that. And they may have been right somewhat. So point person, knowing when you need, the legal counsel contact information, knowing who to call and when, because you'll get records requests, and those requests need to be addressed quickly, but it's helpful to have counsel look at that. And I think I'm already 2 minutes over my time, so I will skip through this, and I will leave you with some resources here. Till 4? Oh, good. Oh, okay. Well, or not. I mean, maybe you don't want to hear from me anymore. For some reason, I thought I was done at 3:45. Okay. Well, that explains why I have so many slides left. All right. Well, so my apologies. So document requests, this is a key area. One thing to keep in mind, so there are certain documents that you're required to maintain by OSHA. I don't know if any of you have heard of the Form 300s, okay? These are a mandatory form. Somebody in your entity should be keeping track of any incident, any injury that occurs through the year. And those forms have to be maintained and kept on file. It's the first thing OSHA asks for when they really perform any sort of inquiry. These are everything from an ankle sprain to a fatality, and that's going to be what they're looking at in terms of, okay, what's actually going on with this company. If you don't have those records, it's very problematic because it is a mandatory record, and it's one of their key ways that they look at how they are able to examine the record of a company. But there are other records that you have, lots of records that are not mandatory by the federal government's OSHA regulations. And they know that people keep things like, for example, notes, shift notes or things like that. People might, write down at the end or beginning of a shift what happened during that shift, right? OSHA loves that kind of stuff because that's really sometimes very honest information, sometimes very damning to the particular issue. And that does not have to be handed over unless there's a subpoena for it or unless you're engaged in some litigation with OSHA. However, people often turn it over right from the beginning, and that can lead to additional problems and inspections. So, as a part of that OSHA response plan, knowing what records you're required to have, knowing what records you're not required to keep for OSHA, and then empowering this person that you've appointed to sort of be the OSHA person so that they know that in the event, maybe it's 5 years from now that they get a request for documents, they know, okay, this is the stuff, here's where we keep this, these are all these other records, we know we don't have to keep those or give those to OSHA right at the beginning. That's where we recommend you have a company policy that they can point to that says, look, we give you the records right away that we know we have to give you. The other ones, we got to sort through it. There are people that have to look at it. We have legal counsel that has to get involved. And it's always a lot easier if there's an existing policy to point to for why you're not giving the government something than just sort of haphazardly being like, I don't want to give you that today. So developing this and thinking it through, again, it might not be until 5 years from now, but in the terrible or unlikely event something serious happens, you'll want to have this in place. Go ahead. Yeah. That's right. So it's very common that your OSHA inspector will say, you know, I'd like to see all your, all the training records and the incident report. They just kind of tick off a list. That's why we always say, you know, can you please put that in writing for us? Because otherwise we have no way to track it. And they will. But, you know, the other problem is their list tends to change. So they'll tell you something verbally, then you'll give them something, you know, people will give them what they asked for, and then they'll say, no, I also asked for this. You're not cooperating. I mean, you know, they'll get mad sometimes for no good reason. So it's just better to just, again, yeah, ask for it in writing, and then it can be responded to and tracked accordingly. So here's some good news. If you maintain appropriate rules, so let's say let's just give an example of proper personal protective equipment in the context of infectious disease or something like that, okay? You've got rules for it, you've got policies, you've trained people, you've gone through really everything you can do to try to make sure that that particular provider is working in as safe of a way as possible. But nonetheless, they don't, right? Let's say they just walk in and start talking to the tuberculosis patient and expose themselves, okay? And then you get cited for it. OSHA does have what's called the misconduct defense, and it allows employers to get out of the citation if they can prove that there was a rule to prevent the violation, that those rules were communicated, generally through training, that the company generally takes steps to discover violations, so regular safety audits. It's not a bad idea for even healthcare providers to routinely have a safety meeting where people can discuss, hey, what did you guys see this month that concerns you in terms of somebody's use of X, Y, and Z? You don't have to, you can all be anonymous, but these sort of things, OSHA is going to look to those policies that you were doing your best to discover violations and to fix them. If you can show all that, and documentation is key, the citation, you will get the citation, okay, but then your legal counsel will then work to get it dismissed by being able to prove this. It's a hard thing to get, OSHA to see sometimes, but we are successful in asserting this defense, again, when the documentation is there. And that's training. So, and the last thing I'll leave you with, and then I'll end a little early so you can take a breath, is employees' rights. So it is particularly important for employees to feel as though they are at least understanding what is happening during the process of an OSHA entanglement, okay? Because people have this sort of natural tendency to do a couple of things. One, they will shut down and just not talk, or they will spill the beans and fall on their sword, possibly to their own, for no good reason, okay? People like to be responsible for things. So you see this in the malpractice side sometimes with providers, like, oh my, this feeling of wanting, this guilt of, oh, what did I do wrong, and this sort of searching, admission of guilt. So it's good to let people know. So the way OSHA works is while they have to go through legal counsel if they're aware of it, to talk to your management, they can talk to any line-level employee as much as they want. And in fact, so I used to be a government attorney, and when you get people that didn't want to talk, well, one of the best ways to reach them would be to call when you know they weren't home, but that you're thinking maybe their spouse was home, and you talk to their spouse. And nothing gets somebody talking more than if you talk to their spouse and let them know that maybe their significant other could be working in a dangerous situation, and you need to know some facts about it. But that's kind of sneaky and nasty, but that's what happens. And so your employees perhaps could be contacted without you even realizing it, and the government will contact their families, will contact them, they will find them in the parking lot, they'll do everything they can to get the, quote, real information from people because they don't want it filtered. So you can let your employees know, though, that they don't have to talk to OSHA. We have a little form when somebody, first gets some entanglement that you can send out that just says, look, first of all, individual employees have a right to counsel. They also can ask for the company counsel to be there. Even though OSHA doesn't want it, if the company can't say we want company counsel to be there, but if the employee says, I want company counsel to be there, well, the employee's in charge, so they have some rights. They can also discontinue an interview any time. So OSHA loves to put people in a windowless room, sit them down, I'm not kidding, sit them down, and they have a computer, and they have a little form that they go through on their computer that asks a variety of questions. And so one, they'll record the whole interview, and often they'll just be like, are you okay if we record this? Well, the employee can say no, but they usually don't. But then the other thing that they'll do is they'll write this sort of narrative based on the interview. But it's not perfect, okay? These are not court reporters. So yeah, they may be recording it over here, but they're going to generate this narrative of this person's statement. And then at the end, they're going to say, sign this, please. And people sign it. But if you read these things, they're usually only telling part of the story, okay? They're usually telling the story from the perspective of the government inspector that's trying to build a case against your company. A person does not have to sign it just because OSHA asks them to sign it. They don't have to even be there if they don't. They don't have to talk to them. They can just walk away. Now, usually we try to stress cooperation and figure out good ways of messaging and, getting people in line, but people don't often understand their rights. And they also have a right to present exculpatory information. And this particularly comes up in the event of a management situation where OSHA is interviewing them, cue Hillary Clinton and the email scandal, right? So she's going to have a right during that interview to present some exculpatory information, I presume. And it's the same thing at a lower level with, perhaps your environmental safety compliance manager who is suddenly in the hot seat having to give an OSHA interview, they can effectively start to prove the case because while their individual liability is not necessarily at stake, if you do go down that road of willful, it's possible that criminal liability could attach. So it's a little sketchy. So with that, I will conclude. Thank you for your attention. Sorry I was confused on the time. Any random OSHA questions before I go? Oh, yes.
They have a right to ask questions, and then that your first time you say, am I suspect?
Yeah, I mean, you can absolutely.
Are you looking at my activity?
Absolutely. And and they'll probably be like, oh, no, they're just looking at company policy or whatever. But I mean, my advice would be, if the thought even crosses your mind that you could have some sort of potential, liability for something, that's a good point to stop the interview and make sure you talk to your lawyer or the company's lawyer. Because there's just no reason. These things don't have to happen in the sort of very high pressure way that they want it to happen sometimes. So it's good sometimes to just slow it down. All right. I think now you get to learn about what EMTALA more. Yeah. So when that Ebola patient shows up at your emergency room, unfortunately, you're going to have to see them, right?
All right. Ooh, my voice is sounding bad. We'll see if we can make it through. We may have to do an abbreviated version. Okay, we're going to, you guys see what that is over there? That's the finish line. We are almost there. Do you guys even want to stick around to hear this? I have no problem with calling it a day if you want to. Anybody? Okay, we'll go ahead. We will try. All right, before we get to EMTALA, did you guys know that Idaho has its own, basically, EMTALA statute? It says that a hospital cannot refuse emergency or first aid services and care by reason of race, creed, national origin, or financial ability to pay. That's EMTALA. What are the penalties? We don't know. There are no penalties associated with it, apparently. I think it's just part of the licensing regulation. So because of that, we don't get too excited about that statute. We get excited about EMTALA, which is the Emergency Treatment and Active Labor Act. It's part of the hospital conditions of participation. That means if you violate it, the government can come in and take away your Medicare certification. In addition, the government can impose lots of civil penalties against you, depending on who you are. Now, what does EMTALA require? Well, it says that EMTALA applies to hospitals, but not all hospitals, only hospitals that participate in Medicare, okay? So if you are a purely private pay facility, specialty hospital, EMTALA doesn't apply. On the other hand, if you're participating in Medicare, then the hospital is going to apply to you, but the rules are going to be a little bit different depending on what type of hospital you have. If you're a hospital that has a dedicated emergency department, you get the benefit of the full EMTALA requirements, okay? On the other hand, if you're a hospital with simply you do not have a dedicated emergency department, but you're like a specialty hospital or one of these other facilities, you're participating in Medicare, so EMTALA still applies, but you don't have the full requirements. The key there is whether or not you've got a dedicated emergency department. So what is a dedicated emergency department, or DED? A dedicated emergency department satisfies one of these three tests, okay? Either it's licensed as an emergency department, or it's held out to the public as a place that they can go to receive care on an urgent basis without a pre-scheduled appointment to provide emergency type services. For example, a urgent care center, right? The government has said, hey, most of the facilities, most of your hospitals that operate urgent care centers, we think those urgent care centers are dedicated emergency departments. What does that mean? If they satisfy this requirement, that means those patients who show up at those dedicated emergency departments, that EMTALA is going to apply there, even if they're located off the campus of the hospital. Those facilities would also have to have the other requirements that apply to hospitals, like you'd have to have the EMTALA signs and those types of things at those urgent care centers. The third test is if during the prior calendar year, even though you didn't hold it out to the public, if people still showed up, you provided at least 1/3 of the outpatient visits for emergency conditions on an urgent basis without prior appointment, then it's going to be considered a dedicated emergency department. The dedicated emergency department is not only ED, it's other places in your facility where people might show up to receive emergency type services without a pre-scheduled appointment. Like, for example, what might that be? L&D, labor and delivery, mental health units. Those are common places that are considered to be dedicated emergency departments, and so you would need to satisfy the EMTALA requirements for those locations also. EMTALA applies to the hospitals. It also applies to physicians. Physicians have an obligation to respond to call if they're on the hospital's on-call roster. If they fail to do so, they can get hit with penalties. What does EMTALA require? Well, generally EMTALA states that a hospital with a dedicated emergency department must, if the patient comes to the hospital, provide an emergency medical screening exam. If that screening exam reveals an emergency medical condition, they've got to provide stabilizing treatment or an appropriate transfer. In addition, participating in a hospital with specialized capabilities must accept the transfer. Okay, so you may not have a dedicated emergency department, but if you're participating in Medicare, guess what? If that hospital, they may be a rural hospital, they don't have the facilities they need, maybe they don't have an orthopedic surgeon, they could call over to that specialty hospital across the way that doesn't have a dedicated emergency department and say, hey, you're participating in Medicare, you have an obligation to accept this patient transfer. And they say, well, wait a minute, we're not an emergency department. But you say, but you're participating in Medicare, you've got specialized capabilities we don't have, therefore you are obligated to accept that EMTALA transfer. Yes, question. The question is whether you're on diversion. If you're on diversion, then you can, well, we'll come to that in just a second. Okay. Yes.
If you have a provider's clinic and they accept one, and somebody comes in there,
so I'm going to, yeah, hold on just a second because I'm going to catch the people up to, if anybody's still offline or online. So we're talking, let's say you have you're a hospital, you've got some other clinic, that provides walk-in services, right? Okay?
So we need to have the same notification for EMTALA at that walk-in.
Do you need to have the same notifications for EMTALA at that walk-in clinic? Yes, if that walk-in clinic satisfies one of these tests as a dedicated emergency department, and but only if they operate as a provider-based department of the hospital. Not just that they're owned by the hospital, but they have to be operated under the hospital's provider number. The theory there is that, look, if you are getting provider-based benefits because you're billing as if you're a part of a hospital, then, hey, you pick up one of the stick, you pick up the other. We're also going to make you comply with the EMTALA requirements. Now, some facilities, some hospitals will operate separate rural health clinics or something that are operated under a separate provider number, not under the hospital's provider number. They're not provider-based. In those situations, then that walk-in clinic would not be considered a dedicated emergency department. Okay. All right. The other requirements are that the hospital cannot delay exam or treatment to inquire about payment. You've got to post the required signage, and you've got to maintain your on-call list. We'll talk about those. What happens if you violate it? Well, physicians can get hit up with a $50,000 fine if they're not going to come in when they're on call. So when you have that specialist says, nah, I'm busy, I'm watching a good show, I don't want to come in, say, okay, is that show worth $50,000? Because, by the way, we're going to have to report you or send your name to the transferring hospital if you fail to show up. So the physician can have personal liability. They can get fined under EMTALA. In addition, the hospital can get fined if the hospital has less than 100 beds, $25,000 per violation. 100 or more beds, $50,000 per violation. In addition, hospitals, not the physician, the hospitals can get sued for damages. The patient can sue you, or if you transfer the patient to another facility and that facility has damages, they have to take care of that patient because you didn't, that other facility could sue you for damages. That's very seldom happens. I do a lot of EMTALA litigation, a lot of EMTALA cases, and I think there's only been one case that I'm aware of in about the last 5 or 10 years where they've actually gone after a hospital for monetary damages. Now, we were able to avoid that, and they went away because we were able to show that we jumped through all the necessary hoops, even though we had a rogue provider who did something wrong. We convinced the government that it wasn't the hospital's fault, so they went away. Okay, let's talk about the EMTALA triggers. For hospitals with a dedicated emergency department, EMTALA is triggered if a person comes to the hospital, a request is made for emergency care, and this is kind of a weird one, the patient is not already a patient at the hospital. The person is not already a patient at the hospital. I'll talk about that in just a minute. That's the trigger for hospitals with a dedicated emergency department. If you don't have a dedicated emergency department, then you don't have to do this for the walk-ins. It's just if a hospital with a dedicated emergency department wants to transfer a patient over to you, then you've got to accept it. Oddly enough, patient just shows up at that facility, they can say, EMTALA doesn't apply to us because we don't have a dedicated emergency department. But if they get a call from another hospital where that patient is, then they'd have to accept the transfer. So for hospitals with a dedicated emergency department, EMTALA is triggered if the patient comes to the hospital. Well, what does come to the hospital mean? Comes to the hospital means it's on the main campus of the hospital, including the parking lot, sidewalk, and driveway. In addition, it's the area within 250 yards of a hospital if it's owned by the hospital, like a provider-based department of the hospital, like your urgent care clinic or something like that. Or maybe you've got a physician office building. The patient comes to, that's within the 250 yards. Now, if that patient is in the hallway there that you own, then it would apply. On the other hand, if he's in a physician office and you don't employ that physician, that's not part of your stuff, then EMTALA would not apply there because he didn't come to the hospital, okay? It also applies if they come to an off-campus facility that constitutes a dedicated emergency department like that urgent care center. In addition, it applies if the patient is in a hospital-owned ambulance, okay? If the hospital owns the ambulance and operates the ambulance, that is like as part of the hospital. And that means before that ambulance can go someplace else, they would need to jump through the EMTALA hoops before they could take them someplace else. Let's talk about ambulances. So if the patient's in a hospital-owned ambulance, EMTALA applies. You can't just send the patient someplace else. It's your patient. On the other hand, if it's not in a hospital-owned ambulance, it's in the local county paramedics, it's in their ambulance, then EMTALA doesn't necessarily apply to that patient in the hospital. On the other hand, you cannot divert that inbound ambulance unless you're on diversionary status. See, I told you we'd get to diversion, okay? If they're if they're inbound on diversionary, you've got to accept the patient unless you're on diversionary status. Now, diversionary status means that you don't have the space or the capabilities to accept that particular physician or that particular patient. What you need to make sure you're doing is before you go on when you go on diversionary status, you need to make sure that you document that. Document the reasons why. And make sure when you consider going on diversion that you not only consider your current capabilities, but also what you've done in the past. Because when the government looks at your capacity, it's not only what you're doing right now, but it's also what you've done in the past. Okay? Now, so what do you do in those situations? Maybe you're a small rural facility. You know that this patient needs services that can only be provided at like St. Al's or St. Luke's. You know that it's in the patient's best interest not to come to our facility because we're only going to be able to patch up the guy so much and we're just going to have to send him out anyway. Can we just divert him on to St. Al's and St. Luke's? What do you think? Not without violating EMTALA if they're inbound to your facility. Well, that's not in the patient's best interest, so what do? There's nothing that prevents you from telling the inbound ambulance that. What you do is you have this conversation with them. This patient needs to go to St. Al's or St. Luke's because they need services that we can't provide. Now, I am not diverting you. If you bring that patient here, we're going to do everything we can for him. But I'm telling you what we're going to have to do is basically we'll do what we can, but we're just going to have to ship them on to St. Al's or St. Luke's. It's far better for that patient to go directly there. Let me make it clear, I am not diverting you. We will accept the patient if you bring them here. But that patient really needs that other care. You can have that type of communication. Just make sure that you don't divert them and make sure that you document that you didn't divert them, okay? Because the ambulance people will probably hear, they diverted me, okay? So make sure that you document that. Yeah, question, Ruben.
Going along with that, the helicopter is already inbound. Land on the property. The patient is going to be on our property. So therefore,
okay. The question is, what about helipads? What about that situation? You've got a helicopter that's coming in. Coincidentally, I foresaw that you were going to ask that question, and my very next slide happens to be with helipads. And here's the rule with the helipads. If they're bringing them to your facility to get treatment or an examination, then you've got to provide the care. On the other hand, if you were just a bus stop, okay, they're bringing them there because you happen to have the only helipad in the county, and the transferring facility has already performed the examination on their part, and all you are is a bus stop, then EMTALA doesn't apply to you unless once they arrive there, they ask for your help, okay? Now, we used to think that the regulation was simply, if they're bringing there and they don't ask for help and they're just going to transfer you or transfer the patient, you're just the bus stop, then EMTALA doesn't apply at all. But the interpretive guidelines now have this kind of weird statement that if the transferring facility has already performed the exam and then they bring him to your place and then transfer him on, then EMTALA doesn't apply. Well, what happens in most cases, no exam has been done, right? You've just got, they picked up the I-15 crash, they brought him to the ambulance rushed them to your facility to meet the helicopter to send them on. What if no exam's been done? That's not entirely clear. The safer thing to do would probably be to at least offer the exam at that situation, or at least have a discussion with them in advance. Yeah, Becky.
So is there any time limit, let's say the helicopter is delayed?
Okay, just for the people who are offline, so let's talk about, let's say that the helicopter is delayed.
So is there any time frame in which, if that ambulance is sitting there, that you need to be offering that medical screening exam, or is it just when they ask? Okay,
so the ambulance is there on your facility waiting for the helicopter. Helicopter hasn't arrived. What do you need to do as the facility? If they haven't asked you for your care, and the exam was already done, and they're just waiting to transfer that person on, then EMTALA still is not going to apply to you, okay? If you do go out and ask for their care and they ask for that, then obviously if they initiate that contact, then they're going to have to provide care. I'd be careful in those situations, though. You may want to contact them and say, okay, do you need us to provide care, or are we just staging the transport? Was the exam already done someplace else? And it might be. The paramedics may be qualified as qualified medical personnel, and so they may have already done the screening exam at the other facility, or not even at another facility, just at the crash site. They may have already done the screening exam. But I would probably have that conversation and then document it. You probably ought to be okay. And the question was, do you just document that in ED log? Yeah, there, or some other appropriate place. The ED log would probably be the best place to do it, however you maintain that. All right. So the first thing is they have to come on hospital property. The second is there has to be a request for emergency care, right? Just because a person's there, we don't throw down, strap them in, and provide the screening exam whether they want it or not. There has to be a request for emergency care. Now, the standard for that request differs a little bit depending on where they are in your facility. If they come to your dedicated emergency department, and essentially if they request almost any kind of care, EMTALA is going to be triggered. They come to your dedicated emergency department and say, I've got a hangnail, you know, and it really kind of bothers me. It's a request for care, and EMTALA is triggered, okay? On the other hand, if they come to not the dedicated emergency department, they come to maybe some other clinic that's not a dedicated emergency department, then the standard isn't just a request for care. They have to request some kind of care that a reasonable person would believe to be an emergency. So they show up at some other clinic, and they're grasping their chest, complaining of chest pain. EMTALA would be triggered at that. But they show up to that other place and say, you know, I've got this hangnail, and that EMTALA is not going to be triggered there. So it depends on where they come, kind of that standard that applies. Now, EMTALA applies if there's a request for emergency care. EMTALA doesn't apply to a request for what is clearly non-emergency care, including the examples are things like preventative care. They show up for a flu shot, or immunization, or as part of your blood, you know, the community outreach, they show up for just a free blood pressure check. Those situations do not trigger EMTALA. They're not there for requesting emergency care. If they show up for requests to perform non-emergency tests, their physician said, hey, go down to the ED and get this test, okay? Then they called ahead, they made an appointment. They're just there to get a diagnostic test. They're not there for any emergency care. EMTALA would not apply to that, but you would definitely want to make sure you document that, okay? If the police bring somebody in, not for treatment, but just to get a test, to get a BAC, blood alcohol test, or some other kind of evidentiary test, EMTALA doesn't apply unless that test discloses a potential emergency condition. Maybe you do the BAC and this person is so drunk, so the blood alcohol content is so high that it creates an emergency situation, then EMTALA would be triggered in that situation, okay? If you show up and you think that this person is not requesting emergent care, document it. Make sure it's clear that when they showed up, they weren't seeking emergency care. Now, oddly enough, EMTALA doesn't apply to patients. What? That's weird. What do you mean by that? Well, remember the background of EMTALA was to provide for those cases where patients came to the hospital, but no physician-patient relationship was established. Remember I told you earlier that there is no duty until you establish that relationship. So there would be situations where patients, you know, with a gunshot wound, they're lying on the hospital property. The physicians would come out and say, well, that's sure a tragedy. Somebody ought to do something about that. But, you know, gee whiz, I don't have any obligation. And they're right. They didn't have a duty. So they passed EMTALA to say, hey, if they come to the hospital, you got to provide the care, okay? Once they become the hospital's patient, once they become a patient, you don't need EMTALA because now you've got malpractice duties. Now you've got the hospital conditions of participation that you got to take care of this person. So once they're admitted as a patient at the hospital, EMTALA ends. You can transfer them. You can do whatever you want. EMTALA ends. It's not an EMTALA issue. They may still have obligations under the hospital's discharge policies. There may still be malpractice liability, but EMTALA ends. EMTALA ends when you admit the person as a patient, as an inpatient, not only for yourself, but also for any hospital that you wanted to transfer that patient to. So you've got a patient, you're a small rural facility, let's say. You get that patient, you bring him in, you admit that patient at your facility, you want to transfer that patient on to St. Al's or St. Luke's, and you call them up and say, we've got this inpatient we want to transfer to you under EMTALA, they could say, they would never say this, I don't think, but they could say, well, gee whiz, we don't have an obligation under EMTALA to accept that patient anymore because he was admitted as an inpatient. That doesn't make much sense, but that's the way the rule is, and the commentary specifically states that. So if you are a rural facility and you think you need to transfer that patient on, you may want to be very careful about admitting them as an inpatient, particularly like, for example, if it's a psych patient or some other patient that's going to need specialized care, because by admitting them, that other facility now is not going to be obligated under EMTALA to accept. Now, most of those other facilities are going to be willing to accept them anyway, whether they want to or not, just because they're good facilities. But that's an issue that you need to consider. Becky?
Saying admitted as an inpatient, what is the place to move to observation?
Okay.
Is that negate EMTALA or is it still apply?
So the question is, we're not going to admit them, we're just going to put them in observation. Yeah, if you just put them in observation, then they're not admitted as an inpatient, so that would not cut off EMTALA. Okay. All right, that not only applies to inpatients, but it also applies to outpatients who've already received outpatient treatment. So you have a patient who comes in for, let's say, a cardiac stress test, and he's like me, you know, you put him up there on the stress test, and while he's doing the stress test, he has a heart attack, okay? EMTALA is not going to apply, okay? Because the patient's already a patient. He's already begun receiving that treatment. Now, there's other malpractice issues that will apply. There's other conditions of participation that would apply, but they've got those other protections, so you don't need EMTALA. Now, one kind of exception to that is newborns. If a baby is born at your facility, they have now come to the hospital, they're a new patient, okay? EMTALA still applies to them, even though it may not apply to the mom, but EMTALA still applies to that baby. All right, so here's the EMTALA flow. Let's say you've got that patient, they've come to your facility, a request has been made for an emergency screening exam or emergency condition. Now here's your obligations. You have to provide an appropriate medical screening exam. If that medical screening exam reveals that there is no emergency condition, EMTALA ends. You can transfer that patient, you can send them home, EMTALA ends. You may commit malpractice, but it's not an EMTALA violation. On the other hand, if you determine that that patient does have an emergency medical condition, you've got to provide stabilizing treatment and or an appropriate transfer. So let's talk about that medical screening exam. What is the medical screening exam? A medical screening exam is an exam that's three elements. It has to be performed by a qualified medical person. It has to be applied in a non-discriminatory manner. And it has to be sufficient to allow the QMP to determine within reasonable clinical confidence whether or not an emergency medical condition exists. The first one, it has to be performed by a qualified medical person or QMP. Who are QMPs? That depends on your facility. QMPs are those people who are identified by a document that's approved by the governing board. The medical staff, the governing board has to approve it. They identify who are the QMPs. Not necessarily by name, but by job classification. So you may, for example, say, only physicians can perform our QMPs at our facility. They're the only ones who are authorized to perform screening exams. I personally don't think that's necessarily a real good idea because you may want to use mid-levels to do that. You may have physicians in mid-levels. In some places, for example, for labor and delivery, you might want to identify labor and delivery nurses as QMPs, particularly if you need to rule out false labor so that you can determine whether or not that person is going to be sent home. So the bottom line is you need to go back and look at your facility documents that are approved by the governing board to identify who has been designated as a qualified medical person, okay? Now, it has to be applied in a non-discriminatory manner. All that means is it doesn't matter whether when J.R. Simplot was alive, if he showed up versus, you know, whoever else might show up down there at your facility. It doesn't mean you give everybody the same tests or that. It depends on the presenting symptoms, right? It's just you would give the same test to everybody who showed up with those same presenting symptoms. So that's the second factor. The third, it's sufficient to allow the QMP to determine with clinical confidence whether an emergency condition exists. That depends on the presenting symptoms, right? You got to perform the exam that's appropriate for the presenting symptoms. You have to perform the exam that's within the capabilities of the hospital. If you don't have sufficient capacity or sufficient capability to conclude an exam, you'll probably need to perform an appropriate transfer of that facility to another place to conclude that exam. But if that person needs, for example, a CT, and you've got a CT, you need to provide the CT, whether or not they can pay for it. If you need a specialist to come in and see that patient in order to perform the screening exam, then you need to call in that specialist to perform that screening exam. It's whatever the hospital has done or could do in order to complete that screening exam. Now, in all the cases that I've had, I think at least 80% of them deal with the sufficiency of the screening exam. And in all of those cases that I recall, I'm convinced they performed the screening, an appropriate screening exam, but what they didn't do is document it, okay? Documentation is key on this stuff. So the screening exam, the government, has repeatedly stated that the screening exam is an ongoing process. It's not an isolated event. Patient comes in, 0100 hours, patient's transferred, 0700 hours. If there is no record of vital signs or ongoing monitoring from 0100 to 0700, they'll probably say that's an improper screening exam. You never gave them a screening exam. They want to see ongoing monitoring through that time period. That exam should include vital signs history, documented physical exam of the involved area or system, if needed, ancillary tests and specialists available through the hospital, continued monitoring through that time. Again, your biggest key to EMTALA compliance, I'm convinced you guys don't violate EMTALA because of the medical care issues. It's a documentation issue almost always. Documentation. You want to make sure that you document an appropriate exam, that no emergency existed if there wasn't one, if there was no emergency condition, that the patient was stable if they were stabilized, that the patient refused care if they really did refuse care, or if you're going to transfer them, the certification that the benefits of the transfer outweigh the risk. It's a documentation issue. Now, that exam has to be sufficient to identify whether or not there's an emergency medical condition. What is an emergency medical condition? Here is the test. A medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, psychiatric disturbances, and/or substance abuse, such that the absence of immediate medical attention could reasonably be expected to result in placing the individual's health in serious jeopardy, serious impairment of bodily functions, or serious dysfunction of any bodily organ or part. That's the test for an emergency medical condition. In the case of pregnancy, in the case of a pregnant woman having contractions, either there's inadequate time to effect a safe transfer to another hospital before delivery, or the transfer may pose a threat to the health or safety of a woman or unborn child. So if the woman's having contractions, she's got an emergency medical condition if there's no time to transfer her to another facility. We'll talk about stabilizing there in just a minute. What about a psychiatric condition? Well, at least in the case of somebody who's expressing suicidal or homicidal thoughts or gestures, they're determined to be a danger to themselves or others. Now, if the person comes in for what is clearly a non-emergent condition, this isn't a situation where they're requesting non-emergency care, like, the immunization, but if they come in and it's clear, it's the hangnail, it's clear that it's not an emergent situation, the government says, well, look, you don't need to send the guy down for a CT scan for a hangnail, right? The hospital need only perform the screening exam necessary to rule out an emergency medical condition. And for some conditions, that may simply be the nurse asking a few questions, maybe taking a quick look at it and documenting. If that's sufficient to rule out an emergency medical condition, you're fine. That's okay. You can go ahead and do it. But it comes down to documenting. All right. So now you've performed the medical screening exam. If you determine there is no medical condition, emergency medical condition, EMTALA is over, right? Don't need to worry about EMTALA. On the other hand, if you determine that there is an emergency condition, you've got to provide stabilizing treatment or an appropriate transfer. Let's talk about the stabilizing treatment. What is stabilizing treatment? Stabilizing treatment, you got to provide it within your capabilities. It's basically such care necessary to assure within reasonable medical probabilities that there's no material deterioration of the condition is likely to result from or occur during the transfer from the facility. Or, in the case of a pregnant woman who's having contractions at delivery of the child and the placenta. Okay? So that if they've got an emergency medical condition, you either have to provide stabilizing treatment or an appropriate transfer. Now, if that patient is stabilized, you provide the stabilizing treatment, EMTALA ends. Okay? So what is stabilized? Well, stable for transfer under the regulations states that there's no material deterioration of the condition is likely within a reasonable medical probabilities to result from the transfer. You can transfer them to that other facility without any decline in the patient's condition. In the case of a pregnant woman, it's delivery of the child or the placenta. Okay? That's stable for transfer. Now, that's the standard under the regulations. The interpretive guidelines, rightly or wrongly, impose a different standard. Under the regulations, it's basically you can transfer them from point A to point B without a material deterioration in their condition. Under the interpretive guidelines, though, rightly or wrongly, the test is whether the emergency medical condition has resolved, even though the underlying medical condition may exist, may persist. Different standard. They're not supposed to change the standard in the interpretive guidelines, but I think that's what they did. I think that that is a standard that makes it more difficult for you to establish that the patient's been stabilized. Okay? So, for example, patient comes in with an allergy attack, which is appropriate given my voice. They come in for an allergy attack. You provide whatever it is you need to. You resolve the emergent nature of that. Now, the person still has the allergies, right? They still got the underlying condition, but you've resolved the emergency nature of that, and that you have stabilized that condition. Now,
you have a patient that you pretty certain is not going to survive into that unless you transfer, but these two tests are going to deteriorate as well and not make you transfer.
Okay, so the question is, what do you do in the situation where you haven't got the ability to stabilize them? You need to send them someplace else or else they're going to die. So under EMTALA, remember I said if they've got an emergency condition, you've got to provide stabilizing treatment or an appropriate transfer. So in that situation, you'd have to have the appropriate transfer. And we'll come to that in just a second.
Sam?
Yeah.
So if you go back, so the pregnant women with delivery, what is using the disinfection stuff?
Okay, so the question is for how do you tell whether a pregnant woman is stabilized? Okay, we'll come to that. Here it is. For a pregnant woman in labor, stabilized means delivery of the child and the placenta. So here's the rule with pregnant women. If the woman is having contractions, the hospital must deliver the baby and placenta, or the hospital must perform an appropriate transfer because they're not stabilized. The only way that you can stabilize them is if you deliver the child or placenta. That's if the woman is having contractions, okay, then she's presumed to have the emergency medical condition, and the only way you can stabilize is deliver the child or placenta. If you're going to transfer them out or send them home, they're still not stabilized, right, because they haven't delivered. They're having contractions. Even if they're a long ways apart, they've still got the emergency condition. They're not stabilized before you can send them home. You know, and it's common. You send them home, tell them to come back when your contractions are this far apart, but they're not stabilized. So in order to send them home, you would have to do an appropriate transfer. You would have to certify that the benefits of the transfer home outweigh the risks, okay? Or get the patient consent, have the patient ask to go home, okay? Now, well, if the woman's having contractions, they're presumed to have an emergency condition and they can't be stabilized until you deliver the child or the placenta. Well, how do you tell whether or not they're really having contractions or whether they're having false labor? You have to have a QMP monitor and determine, certify that it's false labor after a reasonable period of examination, like an L&D nurse. But it has to be done by a QMP. That's why if you do L&D, you may want to identify your nurses as QMPs. So when that nurse calls the physician at home, the physician says, it's in the middle of the night. I don't want to come in to certify false labor. You want to have that QMP be able to, the nurse certified as a QMP so that she can say, no, this is what's going on, it's false labor. Okay. All right. When it comes to stabilizing the patient, again, the key is document, document, document. Make sure that you document that the patient is stabilized. You provided that care. If that patient is stabilized, EMTALA ends. Doesn't matter whether you called ahead for the transfer. Doesn't matter how you sent them to the other facility, in a car or whatever. It's not an EMTALA violation if they're stabilized. They got to document that they're stabilized, because if they're not stabilized and you don't use an appropriate transfer, they're going to cite you for an EMTALA violation. Okay? Yeah, thank you.
So we have a woman who's in early stages of labor, and we're going to do an appropriate transfer home.
Mm-hmm. Okay, so the question is, we've got a pregnant woman. She is in early stages of labor, which according to EMTALA, I understand this is not the clinical definition, but according to EMTALA, if they're having contractions, they're in labor, period. So what happens? They're not progressing. You don't want to keep them there. They don't want to stay there. They want to go home. You want to have them come back. Well, they are unstable. They've got an emergency medical condition that has not been stabilized, so you would have to do an appropriate transfer. We will come to the appropriate transfer in just a moment. All right, so now you've provided stabilizing treatment within your capability. If the patient is stable, or even if they're not stable, if you admitted them, right? Once you admit them, EMTALA is over. So if patient's stabilized or admitted, EMTALA ends. You still have malpractice obligations, you still have discharge requirements, but it's not an EMTALA issue. On the other hand, if that patient's not stabilized, then you've either got to continue to provide stabilizing care within your capability, and if you don't have that, you need to do an appropriate transfer of the patient. So let's talk about what is an appropriate transfer. Okay. An appropriate transfer has to have two things. Okay. The first is you've got to have one of these. Okay. You've either got to have the patient or the representative request a transfer, or a physician certifies that the benefits outweigh the risk. One of those two. Okay. Either the patient requests, so in the case of the pregnant woman says, look, I'm tired of sitting around here, I'm not progressing, I want to go home and watch my soaps. That's fine. You can do that, but because the patient requested it. But you'd want to document it. Or alternatively, you would have to have the physician certify that the benefits outweigh the risks. So what would you do there? Well, the benefits are, I'm not sure, I'm not a clinician, I'm not an OB, I don't know what the benefits, why the benefits would outweigh the risks, other than it's not going to cost them much money. Probably what you would want to do is make sure that the patient requests it. You would explain pros and the cons, and the patient can request it. Okay. All right. So you either have to have the physician certify the benefits outweigh the risks, or you've got to have the patient request it. In addition to that, it's got to be an appropriate transfer, and we'll talk about what that is. Remember, when we're talking about transfer, it's not only transfer to another facility, it's any discharge of the patient from the hospital. So even if they're going home, that's considered an EMTALA transfer for purposes of EMTALA. So if the patient wants to request a transfer, that's fine, but EMTALA wants to see you have the patient sign some kind of a documentation confirming that. The hospital must inform the patient concerning their EMTALA rights and the risk of the transfer. They want you to have the patient sign a written request for the transfer that documents the reason for the requested transfer and that the patient is aware of the risks and the benefits. Alternatively, if you don't get the patient's request, you have to have the physician's certification that the benefits outweigh the risks. That has to be done by a physician. Mid-levels can't do it. Nurses can't do it. Only physicians can certify that the benefits outweigh the risk for purposes of an EMTALA transfer. If you're a critical access hospital that mans its emergency department with mid-levels, now mid-levels is going to have to call your physician, discuss the information with the physician, and the physician has to certify the benefits outweigh the risks. Now, the physician could even come in to do that, or the mid-level can talk to the physician over the phone. The physician could go ahead and make that determination. You could have the mid-level sign the certification, but then the physician would have to countersign it. Only the physicians can certify that the benefits outweigh the risks. Okay, that may change sometime in the future, but not now. They're very clear. Physician has to sign it, certifying that the benefits outweigh the risks. And in that documentation, the government wants to make sure that it's not simply a checkbox, benefits outweigh risks. They want to make sure that they really considered what the benefits and the risks were, that those are documented someplace, either in the medical record or in your transfer form, something like that, to show that there was a true consideration of the benefits and the risks. Okay, so you've got to have either the patient requests the transfer or the physician certification. In addition to that, no matter which one of those, you've also got to use an appropriate transfer. What is an appropriate transfer? That means that the transferring hospital provides treatment within its capability to minimize the risk of harm. The transferring hospital contacts the receiving facility, and the facility agrees to accept the transfer. Now, that doesn't necessarily have to be physician to physician. They just have to contact the receiving facility. The transferring hospital sends the relevant records that they've got available and sends the additional records as soon as they got it. One of those records that they have to send is if the transferring hospital tried to call an on-call physician and that on-call physician refused to come in, they've got to send the name of that on-call physician to the hospital that's going to receive the transfer. And presumably they would, I don't know what they're going to do with it, but I guess turn it into the government. Okay? All right, and the fourth thing is that transfer has to be effected through qualified personnel with proper equipment, including life support and measures. You are not required, a hospital is not required to maintain your own ambulance service to do these transfers. You could use some other facility. Also, there's nothing in EMTALA that necessarily prevents you from transferring a patient by private car, but be careful because the government may second guess you on that. So you're going to want to document that that transfer by private car was appropriate. What are some of the things that you might consider documenting? It is an open book test. Yeah, go directly to, do not pass go, do not collect 200. Yeah, go directly to that other facility. You want to document, I would document that you offered an ambulance, okay, and the patient refused. So make sure that you made that available to them. Make sure the condition is appropriate for that. Make sure that they've got somebody to go with them so you're not having somebody who's bleeding out driving themselves to the other car or driving themselves to the other facility. Give them appropriate instructions for the transfer in the meantime. These are the types of things you're going to want to document to show that that transfer by car was appropriate. All right. EMTALA does not trump a patient's right to consent. A patient has the right to refuse care, but the government says that you should offer the exam, treatment, or transfer. You should, in your documentation, also document the exam, treatment, or transfer that was refused. We offered this, that, and the other, and the patient refused it. Document the risks and benefits were explained to the patient. Document the basis why the patient refused the transfer. Take reasonable steps to secure written informed refusal. And if the patient refused to sign, document why the patient refused to sign. All right. EMTALA says that you cannot delay exam or treatment to ask about payment. Well, what about if you're not delaying? Can you just ask about it if they're just sitting there waiting for the emergency doc to get done anyway? Yeah, you can ask some stuff. You cannot seek pre-authorization from the insurer until after you have conducted an exam and initiated stabilizing treatment. Also, you shouldn't be kind of urging the person to leave. Hey, you could get this care cheaper if you went over to the urgent care center or over someplace else. Do you know how much this is going to cost you? Do you really want to do that? You shouldn't be doing that type of stuff. So long as it does not delay or discourage the exam or treatment, though, the regulations specifically say that you could follow reasonable registration processes like obtaining demographics, obtaining the insurance information or card, identifying emergency contact, but you don't ever condition their treatment on them providing that information to you. You can contact a primary physician or a health plan to obtain a history or identify needs, but you don't seek pre-authorization until you've initiated that screening exam or treatment. All right. Real quickly, hospital with specialized capabilities, as I mentioned, hospitals with specialized capabilities have an obligation to receive transfers if they've got specialized capabilities that the transferring facility does not, either because they've got certain specialties they don't, or maybe the transferring facility is on diversion, or they're out of capacity, or maybe they've got a power outage, whatever it might be. That receiving facility is not required to accept lateral transfers. If the transferring facility has the same capacity as the receiving facility, they don't have to accept the transfer. But if they do have specialized capabilities, they may be able to go ahead and they've got to accept it if they have specialized capabilities. If that receiving facility receives a patient that was not properly transferred, usually what happens is they say that the facility did not call in advance, the transferring facility didn't call in advance, or they transferred a patient that wasn't stabilized and didn't jump through the EMTALA hoops. If you are a receiving facility and have received what you believe to be an improper transfer, you have an affirmative obligation to report that to the government within 72 hours, or else that's an EMTALA violation on your part. Now, I would hope that if you get one of those improper transfers, you would call the transferring hospital first and try to figure out the facts, because quite often the facts are such there really was no EMTALA violation. You just need to know the facts, okay? Either the patient was stabilized, or maybe you did call a person and somebody accepted it and you just didn't know that they accepted, or there may be some other factors that are involved there. On-call responsibilities. Hospitals, one of the things you got to do is maintain an on-call list. Does that mean that if you have a specialty, you must have on-call services for that specialty? No, not necessarily. The government would like to see you have that. If you advertise as having this specialty, The government thinks you ought to have on-call, but it's not a black and white rule. If you've got 3 specialists, does that mean you have to have 24/7 call? No, there is no rule of 3. They realize that in some rural facilities, you may not be able to do the call. The physicians may not be willing to accept call unless you can pay it. Maybe you can't afford to pay for the call. So they give you a lot of flexibility on how you maintain that call list. But you've got to maintain a call list. That call list has to identify the specific physician, not the group, the specific physician who has the responsibility to respond. If that physician fails to respond, then that physician can be liable for penalties. Not all medical staff members are required to take call. The government would like to see you require the physicians to respond within a set time, for example, 30 minutes, something like that. You may use telemedicine. The on-call physician should come to the hospital. I have this sometimes. I feel badly. They got on me for criticizing orthopedists, but it's an orthopedist story again. A situation where the orthopedist got the on-call in my office. Can't do that. EMTALA says you can't do that. The one exception might be as if that orthopedist or ophthalmologist or somebody has a piece of equipment at their facility that they need to use. The general rule is no, the physician has to come to your facility. You can't just send him out to the office. Okay. Documentation, you got to post your EMTALA signs in your designated emergency department. You got to maintain your emergency department log. You got to maintain records regarding the individuals transferred to or from the hospital for 5 years. Okay, in conclusion, avoiding penalties. In the documents I provided you as an article that I wrote about avoiding penalties, but this is a quick summary. First and foremost, always do what's in the best interest of the patient and document it. If you do that, you are almost always going to be okay from an EMTALA perspective, okay? Don't get so hung up on EMTALA that you don't do what's in the best interest of the patient. Do what's in the best interest of the patient and document it. Document, including an appropriate screening exam, whether the patient had an emergency condition, whether it was stabilized, because if it's stabilized, remember, EMTALA ended, they're going to second guess you unless you've got clear documentation of it. If the patient received an appropriate transfer, including physician certification of the risks and benefits, or the patient refused it. Maintain your written EMTALA policies, forms, and signs. Train and retrain staff regarding EMTALA compliance. Again, that's important. That one case that I told you about where the government was going after the hospital, we were able to come in there and show, hey, we provided this EMTALA training. Here's our EMTALA policies. We just had a rogue employee, a doctor who just didn't want to come in at a particular point in time. They violated our policies. We sanctioned them after. The government said, yeah, okay, hospital, not your problem. Physician is your problem. Maintain your on-call list, ensure physicians respond to call, ensure QMPs are identified and qualified, maintain and periodically review your own ED log. Beware transfers of private car, you can do it, but you better document the justification for it. Beware inbound ambulances. Again, you can talk to them, but don't divert them unless you're on diversion. Make it clear that you are not diverting them. Okay. Beware requests for transfer to your facility. If you get those requests, if you've got specialized capabilities, you've got the obligation to accept them. You may want to make sure that it's lateral transfers, that it's, you know, that you really do have specialized capabilities compared to the transferring facility. If there is a potential violation, immediately respond to the suspected violations. Go in there. If you think that there is an EMTALA violation, look at the medical record. See what the medical record says. If the medical record needs to be supplemented because there's additional facts, do it. I'm not saying lie. I'm not saying make inappropriate changes to the medical record, but supplement it. Do a medical do an addendum. If there's additional tests that were done that didn't show up, put those in. If there's additional facts that confirm that the patient was stabilized, put that in. It's better to do it now than years from now when there's an EMTALA lawsuit going on. Get witness statements to the extent that you might need to. There is no duty to self-report your own EMTALA violations. You only have to narc on other people when you get the improper violation. But if another facility says, hey, you know, we got the improper transfer, we're going to have to report you within 72 hours, you may want to be the first one to report because I think that that does buy you some credibility. If the government investigates, if they show up, cooperate with the investigation, gather and supplement with important facts. Again, most of the time you can justify what you did, or you might have a rogue employee. You just need to explain it to them. Additional resources, the government has a website dealing with some EMTALA stuff. I've also provided you with a bunch of information, and I've got EMTALA, I think I've given you an EMTALA policy as a sample. I've also got some EMTALA transfer forms, that type of stuff if you need it. That is it. We are done, just in time for my voice to go out. You guys deserve credit for staying the whole day. I'll be around for another 10 minutes to answer any questions that you might have. Otherwise, thank you very much. I hope it was helpful. And you guys have a great weekend.